son-in-law mine's in Nantucket on this. It's, I liked it. To me, it was the nicest beach. Other than say like Jupiter or whatever. When you go to Houston, when you go to East Coast beach, it's so ugly, especially after the Jupiter. But a really odd one, yeah, I think maybe. Yeah, the olive. No, what was there was a bubble. Yeah, like $3,000.
One time, the Property Insurance Association got some sort of rate.
Oh my God.
And they let us have, just out of curiosity, my wife looking, like, that's nice, but.
Yeah, I think that, yeah, 3-day weekend was starting for $1,100 a month.
Oh, yeah.
That's what
and now that was several years ago. I can't imagine.
That's what they do at Pensacola Beach on Blue Angel weekend, okay? It's like $3,000. I think you gotta rent, is it 3 or 4 days? But it's like $2,900 for 3 days at the Holiday Inn or
No.
But you know what I did? I went to that Hard Rock and paid $2,900 for 5 days. I got an Airbnb. I was calling $200.
Yeah, in the tent shed or wherever the hell you were. It sounded like a rope.
Huh? Just wants to jump out. Man, I wanted one of those. Can I get one for a memento? Thank you. I like them. I can hear the jerk back there saying she liked Forrest Gump also. I don't need it anywhere, okay? It works good, just like it is. It really does. But it's hooked into this. It wouldn't do me any good, right? This is hooked into y'all's system, right? She goes, I don't know, I just get paid. I just show up every morning at 8 o'clock.
I monitor from our recording system itself, which is picking up different audio.
One we use in Milton, I used to go to it, and it's like so awful. The judge was screaming at me. I'm like, okay, I'm sorry. You gave this to me, and it just, I can hear it's that people don't speak up. They're like, you know, it's like the nun. She said, well, you're out on the playground. I can hear you screaming 100 yards away, but then when you come back in the classroom,
You could probably get one of those things on Amazon.
say again?
I haven't looked, but you could probably find one of those on Amazon.
You can find everything.
Yeah, I just wonder if I wear it into a, well, I guess it'll hook to the Wi-Fi. Will it? I'm just wondering. I don't know. Because I surely can't hear it.
It's a really pretty courthouse.
I love the court. I can't hear what you're saying. I can't hear what you're saying.
That.
The craftsmanship that went into something else.
Yeah, I went to the and they gave it some. There's so horrible.
Driving back,
I'm from state.
Yeah. How long did you do?
9.5.
Yeah, I learned the hard way.
It's 600 miles.
I learned that the hard way. Microphones were live. I was trying to fix that would be district.
Kids, why they want to go to DC in the spring? If they want to drive or fly.
I usually travel to North Carolina at least once a year. We shoot up.
So we were going back and forth.
And Long traffic and hours.
Maybe I will.
I had a friend, so then I moved forward and
Not yours.
But they would work in DC. There was no traffic. But I would see them leave at 5 a.m. to beat the traffic because it was over 3 hours. These days rolling hills.
Brother moving Arlington for a while.
You could just see the cars. You know, all I did in New York was to another on the bus. It's wall traffic going 70 miles an hour. It's just like death. But DC is just going 5 miles.
They well, offered a job to lives up there. Big part of her desire to move to Florida. Get the hell away from all of this.
They money now. They money working in DC and then not paying DC bills but living
Oh yeah.
outside. And so they would get to work early 2 hours and take a nap in their cars before work. And they would beat the traffic.
No, thank you. Not interested in that.
Get some more juice.
Subpoena that turns the, or you can, I can actually take care of, obviously, and then go, mail you a, check for the, amount. But yeah. Oh, man, I know. I'll create a problem over here and give it to them and make sure that what want the reimbursement mailed to, Ryan.
Man, I think that phone charge says you're gonna record Dollar General. So when's
Get it done.
James go back to
Sorry.
Sarah Simpson? I bet she gets 30 years. I think I can send this one to her. 22.5. She should have took that deal in a heartbeat.
Old time, Jared.
Yeah, she did that 4 years, maybe 6 years. Huh? We almost did too. But, you know, she'd already done it before. And they were letting her plea, I think, to, I don't know, second degree. I couldn't ever see how anybody could watch this video when she was. He was in that suitcase and think that she was going to trial but not guilty. You know, when I went to Fort Lauderdale the other day to pack it, how many people in the world do you think every time they go to zip up a suitcase, they think of Sarah Brown locking George up in that suitcase, okay? That's what I was thinking, like, wow, this was hard. I wonder how George felt when Sarah was zipping him up in the suitcase. Damn. Scary.
Main City Court's back in
That's
session.
a discovery violation. They had a reason.
Judge, we're ready. We have, both our witnesses are present. The defense indicated they wish to invoke a rule of sequestration.
Let's do that in the jury here so they can see the witnesses and jury list.
Another job or just retired? No new job?
Mediation.
It's a far more difficult job than the one you have.
But only twice a week.
Yeah.
They get your name on their letterhead where you mediate. That's a ticket. Boy, I hit that one, didn't I?
Remember to sit wherever you like. All right, maybe seated. Thank you. All right, members of the jury, any issues that need to be addressed in the court before we begin? If you don't mind, write your name on the front page of that pad, whether you choose to take notes or not. And then if you choose to take notes, start on the second page of the notepad. All right, and the rules to be invoked.
Yes, Your Honor.
All right. If you would state all your witnesses that are here present, please.
Witnesses are Judge Jennifer Johnson and Lieutenant Ryan Young.
Okay. Any from the defense present?
Ms. Neeson.
Ms. Neeson. All right. Any others that may be called to testify that are present?
There are others, but they're not present.
Okay. So any witness that is not present, counsel will be responsible for advising those individuals of the rule. A rule of procedure, speaking to those whose name was called, a rule of procedure has been invoked whereby you'll be required to remain outside the courtroom unless you're in here testifying. And the rule also requires you not to discuss the case amongst yourselves or with anybody. And there's an exception to that. If you wish to discuss it with either attorney, you may do so, just do it in a private location. All right? And it will find a place for the witnesses to wait until they're called in here to testify. And members of the jury, you got to see the potential witnesses that are here. If you can try to avoid having any contact with them as well, for the case concluded, unless it's here in courtroom. All right. State ready to proceed with your opening statement.
We are, Your Honor.
All right, you may do so.
Thank you, Judge. Good afternoon, everyone, and welcome back. Opening statement, opportunity for the attorneys to tell you where the path's going to lead, what we believe the evidence is going to show to you today. And the evidence is going to show to you today the following. You're going to hear first from Judge Jennifer Johnson. Judge Jennifer Johnson is going to tell you about how back in 2016, 2017, how she was assigned in a Dixie County case, a dependency case, and ultimately involving child custody issues. We're not going to get into all the specifics of that case, all right? That doesn't have any bearing on anything we're here with today. But what does have a bearing is the fact that that defendant, Mr. Cam Braun, was a party to that action and took displeasure and disagreement with decisions that were made. Now, ultimately, that case was assigned to a different judge, and we'll talk a little bit about that, but again, not getting into all the details. But this is now 6-7 years ago, okay? And in 6-7 years, Mr. Cam Braun has voiced his displeasure to the judge's office with the decisions made in the case. But then September 2023 took it to another level, and you're going to see it. We're going to play a video here for you today, all right? It is a video that was first seen by our witness on TikTok platform, the social media platform. It was discussed a little bit here in jury selection. And when you see it and you hear it, what you're going to hear and see is the following. Mr. Cam Braun narrating over this video. It's a visual or virtual reality video game sort of setting where he's portraying himself as this character known as the Patriot, who is going to seek vengeance, revenge, whatever one wants to call it, upon this evil Judge Jennifer Johnson, formerly known as Judge Jennifer Ellison. You'll hear all manner of things, how he characterizes her as things such as inbred, child molester, all manner of things. And then what do you do to those? Let's bury the hatchet, Judge Johnson. And then shows the character planting a hatchet into the back of this visualization, this recreation of Judge Johnson. Then, as that occurs, then taking out a shotgun. And this is what we do to the child molested judges, and fires upon them. Judge Johnson, this video has brought to her attention its existence, the alarm it creates, of course, and then it's presented to law enforcement, and ultimately that leads us here. You'll hear from law enforcement. You're going to hear from Ryan Young, Eunice, Louisiana State Police, and he'll tell you about how he went and made contact with Mr. Cambron, and you'll see actually a recording of it, of the interview that was conducted on Mr. Young's body camera footage. It's been edited just to remove irrelevant portions to save time, to add to no understanding of the case. But you will see that interview and you'll hear his explanation about it as the lieutenant is trying to question him and ask about this video. Well, it's more like a movie, and the video will speak for itself. And it's one of these real people. And y'all watch it. And at the end of the day, what we're going to be asking you to do is to return a verdict in accordance with the law, that in this instance, the defendant is guilty as charged of communicating an electronic threat to kill Judge Jennifer Johnson. Thank you.
All right, thank you, Mr. Durrett. Defense, wish to make an opening?
Yes, sir.
All right.
Well, good afternoon to all of you. I haven't exactly had a chance to chat with you yet, but I'm glad to have that opportunity now. So, as mentioned to you before, my name is Yancey Burnett, and so here to of course defend Mr. Cambron along with Mr. Burns. And so, in so doing, one of the things that was mentioned to you before, has been mentioned a number of times, is that what the case is about, and kind of our perception, our understanding of what the case is about. And it's already been mentioned, but it's worth repeating that what we say, we lawyers, we aren't testifying. I'm not testifying, neither is Mr. Durrett. What is testimony is what comes from the witness stand. What is testimony and what matters in terms of evidence is what the evidence shows. That means the video that have been discussed so much and so forth. And so in all that, we believe you're going to see something quite different than what you were just told by Mr. Durrett. And so a couple of things about there are two aspects to this case. One of them has to do with reasonable doubt, and so it's already been discussed a bit about reasonable doubt, what that means, that they have an obligation not just to prove one part of the case, but they have to prove every element of their case. So they have to prove that Mr. Cambron created this particular video in question that they allege is a threat. They have to prove that there was something beyond just the creating of the video. They have to prove that he posted the video. I can tell you now, I think they're going to have a problem with that. They're going to struggle with that. They're just not going to have much of any evidence that he posted anything. And that doesn't mean that it's your job or somebody else's job to fill in the blanks for the prosecution. In other words, it's not your job to create evidence for them. It's not your job to like put two and two together or something like that. They have to actually prove these things. Beyond that, they have to prove another thing that's really important. They have to prove that Mr. Cambron had an actual true intent to harm when he made this threat. And so there are a lot of basic facts that are, I guess I describe them, and I think the evidence will show that they're kind of immovable objects, if you know what I mean. In other words, these are things that don't change. The fact is that what Mr. Durrett mentioned is true, that there was an event happened in 2016, and it did not go Mr. Cambron's way, and Judge Johnson was the judge in 2016 having to do with that court process, and he was upset about it, and he was unhappy about that. And when he was unhappy about it, it has been 8 years since that occurred. So when we talk about the true intent that somebody has, over the course of 8 years, you would think that intent might be carried out. But the evidence is going to show that over the course of 8 years, from 2016 to today, not a single affirmative step has ever been taken by Mr. Cambron to carry out any threat. None. Zip, zilch, zero. That's the evidence that's going to come forth today. We have some idea of what the evidence is going to be because we have what's called discovery, where we do some depositions and we get documents from each other, stuff like that. So when the lawyers are talking about what evidence is going to come, we have an idea of what's going to come because we've gone through this process. And so I would imagine that Judge Johnson is going to testify as she did before, and there's not a single affirmative physical step ever taken toward hurting or harming her by Mr. Cambone over the course of 8 years. Not only that, but there are 3 things that he's done to really separate himself from Judge Johnson. He's moved 3 states away. He's moved 600 miles away. And he's had 8 years of time that have passed by and not a single affirmative step taken toward hurting or harming. So what does all that leave us with? You know, it leaves us with what is, I think, a good defense for Mr. Cambone, and that is that he has a First Amendment right. Even judges can be complained about. I think we see our own political discourse at some
Your Honor, I'm going to object at this point. This is opening statement, not argument.
Okay, well, I'm going to talk about what the evidence is going to show. And so when we're talking about the evidence and what that evidence is going to show, you know, the First Amendment allows us to have this right to speak and to have free speech. And so in terms of that free speech, I think what you'll see from the evidence is that everything that Mr. Cambone said falls within that category. It may be crude, it may be exaggerated, you know, he's got this kind of exaggerated way of talking about these things, and it's crude. I mean, it wouldn't be maybe something that, you know, a lot of other people would say, but nonetheless, I think the evidence is pretty clear that the U.S. Supreme Court talked about it in terms of crude hyperbole, and I think that's what the evidence will show, that crude hyperbole is actually protected by the First Amendment. I mean, these are things that are, you know, that maybe somebody wouldn't say, or you might not agree with them, but it's not about agreeing with him. Even about this topic, it is about, you know, is it protected speech or not? And so protected speech has 2 kinds of things. You know, there's protected speech like what comes out of your mouth, but there's also this right that we have under the First Amendment to redress grievances. In other words, to complain, you know, to our officials in a real way. And so that, I think, members of the jury, is what exactly was going on here. You know, Mr. Durrett mentioned the animation itself, and so we sometimes refer to it as a video. It's not a video. You'll see it. And I think the evidence is going to be pretty clear. It's not a video. It is an animation, though. And there's a voiceover over the animation. And in the animation itself, that voiceover refers to a number of different things that are all things that never occurred and aren't true. And by that, I mean, none of the events in that video have come to pass. Every single thing in that video, and there are specific references, just like Mr. Durrett said, to, you know, Judge Johnson in the video, and there are references to today, you know, there's going to be some, you know, kind of justice, some sort of justice meted out, and it's crude. But still, members of the jury, we're still talking about all things that never occurred. These are all things that never happened. And so, in the end, we're absolutely going to ask you for a verdict in favor of Mr. Cambone. There are, I think, and I would suggest to you, and that evidence will show, multiple reasonable doubts to have about what occurred here. He has a First Amendment right to say these things. I think the evidence will show that, you know, crude hyperbole is a pretty good description for what it actually is. But beyond that, beyond the multiple reasonable doubts, we will absolutely ask you to return a verdict in favor of Mr. Cambone, that he is not guilty, that there are reasonable doubts, that they haven't proven their case sufficient to convict him under the law, all of which consistent with the law. And thank you for your time. Appreciate it.
State, call your first witness.
State calls Jennifer Johnson.
Jennifer Johnson, please.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Will you please introduce yourself to the jury?
My name is Jennifer Johnson.
Jennifer Johnson, what do you do for a living?
I'm gonna live just a minute. I'm the county judge in Dixie County, Florida,
And how long have you been the county judge in Dixie County, Florida?
since January 5th, 2015.
And prior to becoming the judge, what did you do prior to that?
I had a private practice, law office there in Cross City. I also served as the county attorney and the school board attorney, both of those for a period of 4, 5, 6 years.
And your married name now is Johnson,
I'm
correct,
married.
as we've established. What was your name your last name prior to becoming Johnson?
Ellison. I took the bench as Jennifer Ellison, and then I married my husband in 2017 in February and changed my name to Johnson.
All right, so when you took the bench, you were Judge Jennifer Ellison, and you've since gotten married, and your name is now Judge Jennifer Johnson.
Yes, sir.
Okay. I know it sounds silly, but we're going to talk about some videos and whatnot later on, and that's why I ask you those questions. And now, it is strange for me asking you questions here to say Judge, Miss, Judge. Judge Johnson, I want to take you back 2016, okay? And were you involved in or assigned to a case, a dependency case involving Mr. Cambron as a interested party to that action?
Yes, as an acting circuit judge, I was assigned to the dependency case.
Okay.
That he was a parent.
And then ultimately, Judge, did you preside over the case through its entirety, or did it ultimately get assigned to a different judge?
I presided over the case for about a year, and then a different judge, I recused off, and another judge came on in May of 2017.
Okay. And so ultimately, orders were entered in that particular case, correct?
Yes.
And when would you say that case became final? When it was closed, just ballpark?
I'm not quite sure. I think it was pre-COVID, maybe 18,
Okay.
19.
So began around 2016, we'll just say ended around 2018. But, and since it is concluded, Judge, without getting into any specifics or anything, but since it is concluded, has an individual named Christopher Cambron conveyed his displeasure or disagreement with decisions that were made in that case to you?
Many, many, many times.
Many times. And then has that been, since the case began some 7 years ago?
I don't remember if it was right at the beginning, but it was, if not, it was very shortly after. So it's been 7 years.
Okay. Now I want to talk to you about a specific video. And you've had the opportunity to review what's marked for States ID purposes only at this point as States Exhibit 1 and States Exhibit 2 video footage purportedly taken from TikTok.
Yes, sir. I've viewed both of those.
And do the States Exhibits 1 and 2 accurately reflect that video as you observed it back in September of 2023?
Yes, sir.
And that it also, as it relates to States Exhibit 2, fairly inaccurately depicted where one would go to view that video back in September of 2023.
Yes, sir.
Okay. Your Honor, we would request permission to publish States 1 and 2, well, first, to offer them as evidence as States Exhibit 1 and 2, and then request permission to publish.
Any objection?
Yes, Judge, objected insufficient predicate, and also, at this point, they haven't even established, relevance to the particular charge.
Response?
I think we have established that these are fairly inaccurately depicted, but we can get more into the relevance as to how it relates to.
Go ahead.
Okay.
Sustained at this point.
All right, so let's go to September 2023, Judge. Now, do you become aware of a video that exists somewhere on the internet that references you specifically?
Yes, sir.
And were you able to locate this video back in September of 2023?
Yes, sir.
And were you able to view it on your computer and or cellular telephone or whatever device it may have been that you tried to access the video for the first time?
Pardon?
Objection leading.
Overruled.
The first time that I viewed it, it was from my cell phone. Yes, sir.
Okay. And where did you go to view it?
TikTok.
TikTok. And when you viewed the videos, were you able to recognize the voice that was contained in the videos?
Oh, yes, sir.
And you told us that you were initially assigned to a case involving Mr. Cambron and that you received a number of communications from him during the pendency of that case and after it was finalized.
Yes,
Are
sir.
you clearly able to recognize and discern Mr. Cambron's voice due to your familiarity with it?
Yes, sir. I heard his voice many times in court, and he called my office many, many times and left messages where he identified himself, and his voice is kind of unique. I recognized it.
All right. And the videos that state is attempting to introduce at States Exhibit 1 and 2 for identification purposes, do those videos fairly and accurately depict what you observed? One, the video itself, and two, of it going onto TikTok to view the video?
Yes, sir.
And in those videos, do you hear your name being referenced?
I hear my name being referenced, and then other things that clearly identify that he's talking about me.
And in the video, are there violent acts directed towards somebody that is being called by your name?
He chops my head up with an axe and then shoots me. Yeah.
Your Honor, we'd offer what's marked for ID purposes, States 1 and 2 at this time, as States 1 and 2.
Any further objection?
Insufficient predicate.
1 and 2 will be admitted over objection, and you may publish them to the jury.
Thank you, Your Honor.
You gonna publish them on that screen?
Yes, sir, Your Honor. I apologize. I just needed to confirm one thing with Mr. Burnett, and we are. It should be pulling up shortly.
That's fine. And it should be on your screen too.
Oh,
Speaking to the jury, can you see that screen? Sometimes the reflection's bad, depending on the time of day, but y'all can see it okay? And since these exhibits are gonna now be published, keep in mind any exhibit that's admitted into evidence will be permitted with you when you go back to deliver upon your verdict. From time to time, exhibits that are admitted will be published out here, but that's not your last chance. If you want to review it again, you can. And that goes with any exhibit that's admitted.
All right. Thank you, Judge.
Yes, young lady, you may. Just enjoy the picture, enjoy the view of America's patriot who puts bullets in the heads of fucked up lawyers, culture of child molesting shits in Florida. Every fucking lawyer is worse than a Catholic religion. You thought the priests were bad. Wait till you go get a hold of the Florida child rapist known as Fecal Freak Fegal and Judge Johnson, who likes to play with little boys Johnson. I'm going to execute him today. Young lady, you can have my autograph.
You're my hero.
And look at who we got here, Judge Johnson. The judge that likes to play with little boys' Johnsons. This sick inbred pig, once known as Judge Ellison. She had a secret affair, adulterous affair, and divorced, left her family, her 4 children, to go on to molest other children with a child molesting husband. What do you think it's time for? What are you doing? Look at that. Her inbred cleft nose is having trouble breathing like those inbred dogs. A mutt of a human. That's why she molests children, and she likes to hurt them. She plays with their Johnsons and she hurts them. She makes them cry and she puts in records. She says the children are happy. What should we do? Well, to stop her from harming any other children, I think it's take down time. Execute the child molester so she doesn't hurt anybody else. Judge Johnson, let's bury the hatchet. Judge Johnson, you violated human rights. Child molester. That's the end of all child molesting judges. Execution. The Patriot is here to save us from the pedophile PD. He's here, the American hero. Every judge who molested every child will be hung, executed. The Patriot is here to save the day.
That was State's Exhibit 1, and now publishing State's Exhibit number 2.
Can I get a picture of the great Patriot?
Yes, young lady, you may. Just enjoy the picture, enjoy the view of America's Patriot who puts bullets in the heads of
Can you
fucked.
stop it a second? I'm sorry. I can't, let's see if he will, if you're able.
I can play it, and again, we will have a computer available to go back with them, Your Honor. As recorded, I don't have the technological savvy nor the ability in this to expand it.
It should be able to expand it on the lower right corner of the actual video. I think that's where you expand it, right? On the actual video.
This,
Bottom right speed and microphone.
the little box right here? Yeah, this is a video recording of TikTok. It's not, I cannot from within this State's Exhibit 2 control TikTok. And I apologize again.
I apologize. I thought you could be able to because I know there's a way to.
This way. And
Okay, keep in mind, any exhibit that's admitted, you can take back into the jury room and look at it and comment.
It'll be easier that way.
All right, you may continue.
thank you.
Sorry.
Can I get a picture of the great Patriot?
Yes, young lady, you may. Just enjoy the picture, enjoy the view of America's Patriot who puts bullets in the heads of fucked up lawyers, culture of child molesting chicks in Florida. Every fucking lawyer is worse than a Catholic religion. You thought the priests were bad. Get a hold of the Florida child rapist known as Fritz Fiegel and Judge Johnson, who likes to play with little boys Johnson. I'm going to execute him today. Young lady.
I'm going to pause States 2 at this point And if we continue to watch it, Judge, does it show that the video that we just watched in State's Exhibit 1?
Yes, sir.
And when you're looking there at the screen in front of you, State's Exhibit 2, where we see right now, when I move, can you see where my cursor's moving?
Yes, sir.
And then underneath the video, it says what appears to my eyes to read Brenda Cambron 5-0. Do you know an individual named Brenda Cambron?
Yes.
Who is Brenda Cambron?
Christopher Cambron's wife.
The person that we're talking about here today, as this voice that you recognize, these cases that you've handled, these communications that you've had, is that person here in the courtroom today. The one we're talking about is Christopher Cambron.
Yes, sir.
Can you please tell us where he is seated and what he is wearing?
He's seated over at that table with the light blue shirt on, beside the lawyer with the earphones.
Is he wearing a jacket or not?
He's not wearing a jacket, he's got on a tie.
Thank you. Your Honor, we'd ask the record to reflect that the witness has identified the defendant.
Any objection? No objection. It will so reflect.
And when you first viewed this video back in September of 2023, Judge, were you in Dixie County?
Yes.
You were in Dixie County back then when first viewing this video?
Yes.
And you viewed it subsequent times while
Yes.
in Dixie County as well? Okay. May I have just one moment, Your Honor?
Yes, you may.
Judge, once you see this video, did you feel threatened by it?
Yes, sir.
And once you saw this, did you contact law enforcement?
I was actually, law enforcement contacted me.
I have nothing further, Your Honor. I tender for cross at this point.
You're welcome. Cross-examine.
Judge, may I have just 1 minute to confer with him?
Yes, we'll be at ease moment.
Thank you, Your Honor.
Yes, you may proceed.
Yes, sir. Judge, just a few questions for you on this day. You and I have met before, you remember?
Yes, sir.
Okay. Had a deposition with you a couple of
Yes,
months
sir.
back? Except then we met by Zoom, right?
Yes, sir.
Okay. I guess we can start to some extent where we kind of left off. Might as well, it's kind of fresh for us. In the video that was just played, it's true, isn't it, that in the course of that video, the narrator specifically says that the Patriot is going to execute them today, right?
Yes, in the video it says that.
And I'm putting specific quotes around that. That's the exact language, right?
Okay.
And you also said in response to a question from the prosecutor that your head was chopped by the hatchet. That's what you said, right?
Yes, sir.
You understand that none of those things actually happened, right?
I'm sitting here, yes, sir.
Well, yeah, exactly. Exactly. You're sitting here now, and so none of the things that occurred in that video actually occurred in real life, right?
No, sir.
You didn't get hatcheted, right?
No, sir.
You didn't get executed that day, right?
No, sir.
And from 2016 to today, when you first came into contact with Mr. Cambrone, there's been no affirmative physical step towards you to hurt you or harm you in any way, shape, or form, right?
I disagree with that.
Has he ever physically assaulted you in any way?
He has never physically assaulted me.
Has he ever hit you, kicked you, punched you, anything like that?
No, sir.
And so when you say you disagree with that, you're talking about his words, right?
Yes.
And so he has never gone beyond words with you ever. Isn't that right, Judge?
Well, calling my office and
Judge,
leaving
please
a-
answer the question, Judge.
Okay, ask it again.
He has never gone beyond words with you ever. Isn't that right?
Well, I would say making a point to contact my office would be more than words, but no, he has never touched me.
And so he has called your office and he has complained, right?
There were complaints in it.
Yes. And he has called your office and he has said unkind things about you too, right?
Yes, sir.
And he has called the office and he has said what you believe to be untruthful things too, correct?
Yes.
And so he has done all that in an effort to redress his grievance with you that he thinks you were wrong in what you did back in 2016 in your handling of that case up until whenever you left the case, right?
Yes, sir, but he also did say some other things.
And all of these are complaints that he has made about how you did your job, right?
No, sir.
He's not complaining about how you did your job?
He has, but you said all the things are only complaints, and I
Every-
said no to that.
Every one of those phone calls that he made to you was to complain about how you did your job and the result of that case, correct?
I think it was his anger and frustration at me about the way I handled the case.
Okay.
But it was more than just a rehash of the case. It was a lot more at times.
Yeah. He was absolutely frustrated and upset and angered even by how you handled the case. Isn't that correct?
Yes, he was.
So the one of the things you mentioned before was that this video that you were looking at, it was attached to or connected to, I think you identified it as Brenda Cambrone 50, right?
Yes, sir, that's what's,
Okay. That's the wife of Christopher
Yes.
Cambrone, right?
yes, sir.
So it was, this video then was obviously uploaded to Brenda Cambrone's TikTok account, right?
I saw it on the account that's identified as Brenda Cambrone 50.
Okay. In deposition, you said that it was created by Mr. Cambrone, Christopher Cambrone, and it was uploaded to Brenda Cambrone's TikTok account,
That's
right?
what I believe, yes, sir.
Okay. There's never been an instance where Christopher Cambrone has been like stalking you or following you in any way, shape, or form. Is that correct?
I would disagree with that.
He has stalked you?
I don't think that he's followed me, or I don't know of it, but I mean, the multiple times he called my office and said the things that he said, I do believe would be some sort of stalking. I do.
Okay. Judge, he's never followed you anywhere, has he?
Not that I know of.
You've never seen him at your house, right?
Not that I know of. I've never seen him there.
And the only time you've ever seen him at a courthouse was when he was in a parking lot next to his parked car, right?
Or in my courtroom.
Or in your courtroom?
Yes,
yeah.
sir.
Okay. And those are the only times you've seen him, right?
That's the only times I've seen him.
And you've never physically seen him at any other time in any other location other than those limited locations that we just described, right?
That's the only time I've ever seen him with my eyes, yes, sir.
Yeah. when Christopher Cambrone called your office, you never actually spoke to him once over the phone, did you?
I don't recall ever speaking to him over the phone. He left messages.
Okay, well, that was the question. So you never spoke to him, not even once, right?
I don't think so, no, sir.
Okay. 'Cause generally, it would be Miss Neesmith, your assistant. She would be the one that answers the phone, right?
She would, but he went through a time period there where he would call after hours so he could leave these horrific
Judge, can you
messages.
answer the question I asked, please?
Yes, sir. He would typically, if it was during office hours, he would speak to Miss Neesmith. If not, a lot of the calls were left on the voicemail.
So there are times when he called, but he never talked to you directly, right?
Yes, he never,
And so in all those calls that you were complaining about how you feel stalked by that, the fact is, in all those calls that you're talking about, you never actually spoke to him. Isn't
he
that right?
spoke to me, but I didn't get a chance to speak back to him.
You never had a conversation back and forth with him, ever?
Not outside of the courtroom.
You never had a conversation with him when you were in your office and he called, right?
No.
Never happened?
I
Not
never
once.
spoke to him, but he addressed me in the voicemails.
Yes, he left you voicemails, and he also called the office to talk to you, but you never spoke directly to him, not a single time, Judge.
I didn't speak to him on my office phone at all.
Ms. Neesmith did, right?
Yes.
Your
Well,
assistant?
Yes,
That would
I
be
think
your.
she did.
That would be your assistant,
My
right?
judicial assistant, yes.
Okay, so she's the one that would have that interaction with him, or somebody else in your office, right?
It would be Miss Neesmith or my answering machine.
Okay. As to the video itself, you don't actually know who posted the video, do you?
I believe I know now.
I asked you in deposition, and you very clearly said you had no idea who posted the video.
I didn't at that time.
Okay.
I mean, I didn't know on my own.
Judge, you have no personal knowledge of who posted that video, do you?
I don't have personal knowledge of who posted that video.
Okay, you know, in a courtroom, that's what matters. So
Well,
you know, don't you, that you have no personal knowledge of who posted that video, do you?
I do know. I do not have any personal knowledge, but I reviewed evidence for court today.
That answers the question. Thank you, Judge. So did you read the disclaimer that went with the video?
I did not.
Are you aware of the disclaimer that went with the video?
I was not aware of the disclaimer, and I don't know if there's one on Brenda Cambron's TikTok page or not.
So the video that we've all referred to as a video, you understand that it's not really a video, it's an animation, right?
Oh, yeah, that's not really me. That's an
Okay.
animated
and-
representation of me.
And it's not just an animation, but these are avatars, right? Or they're sometimes referred to as avatars. But anyway, we'll stick to animation then, okay? If that's more comfortable for you.
Yeah, I think of the movie when you say Avatar, and I'm
Okay.
not blue.
No. We'll stick to animation. So this animated character of sorts, obviously, that animated character is referred to by your name. Obviously, not you, different color hair, but nonetheless, it's referred to specifically by your name, right?
I think she was blonde with a little
Was
bit
she?
of brown in it. Yeah,
Okay.
so I think
I thought she had different color hair, but okay. You be the judge of your hair color, not me. All right. And so, you understand the entire video itself is fantasy in the sense that none of it ever
I
actually.
object to this as counsel testifying.
Sustained.
Do you perceive the video as real or fantasy?
I perceived the video as a real threat. That's the way I perceived
Okay.
it.
The question I asked you is whether you perceive it as real or fantasy.
I don't believe that it's a live video with actors. I believe it is an animation.
And none of the things that are presented in that animation actually occurred. You understand that, right?
Yes, sir.
Did you participate in a conference call in regard to Christopher Cambrone?
More than one, probably.
Did you have a conference call where you were involved and Judge Fiegel also was involved and Florida law enforcement and the prosecutor?
Yes.
Okay. Who was it that instigated that conference call?
I don't remember if I wanted to speak with Judge Fiegel and FDLE or if it was Judge Fiegel's idea.
Okay. During the course of that conference call, did Judge Fiegel suggest that Mr. Cambrone?
Objection calls for hearsay.
Go ahead and finish the question.
Did Judge Fiegel suggest during the course of that conference call that Mr. Cambrone should be prosecuted under the statute that he's being prosecuted under, 83610? So what was the purpose of the conference call?
Well, I've been being contacted in phone messages, and basically it seemed to me as if it was just escalating and escalating and escalating. And I wanted I wanted to see what could be done about it. I was feeling threatened, and
So you wanted some action?
some action, some help, some protection, some
You wanted some
figure
action?
out where this person is that keeps, it started soft and it just kind of ramped up.
So is it fair to say that you wanted to be involved in that conference call because you wanted to instigate some action against Mr. Cambrone?
I wanted to be involved in that conference call because I didn't think that FDLE knew of the numerous calls, because I just reported it and made a report to my local sheriff's office every time.
So
I
okay.
wanted somebody to look at the big picture of where we are now.
And so part of the process for you in that conference call was to make sure that you gave them information that you thought would lead to and instigate a criminal charge against Mr. Cambrone.
The main purpose of the call at that time was to make sure that there was one agency in Florida that could see all of the issues that I had been having, that all the information was in one place, and that could provide me protection if I needed it, to see if the threat was real or prosecute.
Judge, can you now answer my question, please?
Yeah, well, you asked me why, so I'm trying my best.
I didn't ask you why. I asked you if the purpose of the conference call was to instigate a criminal action against Mr. Cambrone.
I thought I started my answer with the purpose of, that was one of the purposes,
Okay.
yes.
4 questions ago, I asked you why.
Yeah,
Now I'm asking you a different
One
question.
of the purposes was because it had gotten to the point where I was fearful and I wanted something done.
Okay. So the answer is yes, you did instigate and participate in that
I
conference.
participated,
You
but I don't remember if it was me or
Okay.
Judge Fiegel that instigated.
Well, that's why I changed it to participated. So you participated in the conference calls to instigate a criminal charge against Mr. Cambrone, right?
Yes.
Nothing further, Judge.
Yes, sir. May I have just one moment? I'm going to ask a question of my partner here. May I proceed, Your Honor? Thank you. Who makes the decision to file a formal charge in the Third Circuit of Florida?
You do, Mr. Direct.
Who instigates a formal charge in the Third Circuit of Florida?
You do, you file it.
Do we agree on everything, Judge?
No, sir, we do not.
Now, persons that call your office, okay, that they've been a party to a case, do persons like that, do they communicate directly with the judge?
No, sir.
Why don't judges talk to everybody that's involved in a case that they're handling?
We're precluded from doing that to make sure that when we go into the courtroom, that we're unbiased when we get there, and it is a breach of the rules. I can't talk to one party without another party in the courtroom with their lawyers there. I can't.
And you talked about, defense was questioning you about how he was just trying to redress grievances associated with the case, but you weren't really getting to answer everything about it. So I want to go back a little bit, okay? And you said something about how, there was these voicemails that be left, after the office was closed.
Yes, sir.
And were they redressing grievances? Well, how would you characterize these voicemails that he's leaving your office in the evening?
Characterize them?
What were they?
Well, he was saying things that I was a child molester, that I think one time I was a son of a child molesting piece of shit, and that I don't recall if it was the voice messages or the videos where he kept saying, he had a history of saying things like, pigs and judges and child molesters need to be shot, and then he would call my office and leave messages that I was a child molester. So it was kind of like fill in the blanks.
Right.
And then one time he actually said, target number 1, Judge Jennifer Johnson, target number 1. So.
And when you say you were answering the question, you were talking about being stalked or followed, and those can be two different things. You don't know if he's followed you because you didn't see him, right?
I didn't see him, and I didn't have any protection to know, but I don't think he was. I wasn't made aware of it.
And when we're talking about, when you say, well, no, I haven't, he's never stalked me.
Objection relevance, Judge. We're getting into the issues of pre-trial conference. I think we're going to borrow those at this point in time.
Based on the cross-examination, the objections are over.
And, when we're talking about stalking in Florida law and repeated conduct of harassment serving no legitimate purpose, what would you say in that 6-year period of time that Mr. Cambron's doing that constituted at least stalking to you?
Well, basically for almost 7 years, he would call the office, and sometimes it would just be repeated over and over again, and then there would go a few months where there would be nothing, and then he would start again, and posting the videos mentioning me, and then at one point there was a period where it was like you could count on it. Every Friday after the office closed, he would leave a message until the answer machine cut off or whatever. And then it would stop for a while. So I thought it was stalking under, I felt that way about it, and I think it is, and I think it was. It was never pursued as that, but.
Right. And then, if there's let's say a letter that goes out of your office by Miss Neesmith related to a particular case, do you review that?
Yes, before she sends it out, even if she signs it, usually she prepares or she types the letters that I send out and sign, but before she'll send it out on my letterhead, I look at it.
Now approach the witness, Your Honor.
You may.
I'm gonna show you two pieces of paper, which, I put my pen down, but the longer dated, at least reportedly May 2022, the second being June 7, 22, and then ask you to take a look at these. May 20th is gonna be State's Exhibit 4 for identification purposes, and then State's 5 for identification purposes. Ask you if you take a look at those, if you recognize those two people.
Yes, sir, I recognize them.
And those letters, State's ID 4 and 5, are they fair and accurate representations of letters that were sent from your office to Brenda Cambron, and then Brenda Cambron and Christopher Cambron?
Yes, sir.
And do they appear to have been altered or manipulated in any way, Judge, since they were prepared and sent out from your office?
The only thing that I noticed was it looked like at the top of the letterhead, it looked where it had been included in the case file.
Yes,
That was
ma'am.
it.
Okay, so after it left your office, then that documentation would just be indicating that it went into the court file.
Into the e-filing portal. When we send a letter to someone, it goes in their file.
Okay, and then is that kind of about what you were talking about earlier? You can't talk to people about a case. Are you kind of?
I'm precluded from talking to them. So
Yes,
if we
ma'am.
communicate with them, we've got to put it in the court file.
Yes, ma'am. You prepare a letter and then you put it in the court file so that everyone can see it. Your
Yes,
Honor, we'd offer what's marked ID 4 and 5, S States 4 and 5.
Any objection?
No objection.
Number 4 and number 5 will be admitted.
May I publish to the jury?
You may.
Thinking, Judge Machado, I wasn't anticipating. I don't have it on a slide, but I could probably find it. May I have a moment to do it that way, Judge? I think it might be quicker. first, what's in evidence, State's Exhibit number 4, just publishing it for everyone to sit here and read, and then followed by State's 5.
Next to the exhibit.
Yes, sir. Going to move now to State's Exhibit number 5. Your Honor, at this time we have no further questions.
All right, thank you. Any recross examination?
I don't have any more questions.
No, okay. Next step down. Members of the jury, we're going to take a recess at this time. We've got about almost 20 minutes till 3. 15-minute recess, and during this recess, if you would please remain in the jury room. Again, you can use cell phones. Don't talk about the case with anybody while you're there. You're welcome to do that as long as you don't discuss the case or do any research about it as well. Make sure you leave your notepads here. The admonishment I've given you throughout will remain in effect. Any further instructions requested?
No, Your Honor.
From the defense? We'll be in recess for 15 minutes.
He motioning us or Brian Buckles? Huh? Is he motioning the lawyers or Brian Buckles? I think it was Brian Buckles.
I couldn't hear you.
I said, was he motioning to us or to Brian?
Did he come out and do that?
Do that.
Oh, yeah, he probably. You want to fight?
Take that recall at this point. Yeah, we didn't say it on the record like we normally
That's why. How you got rid of it?
Turn the volume down.
Turn the volume down over here.
No.
That's how I got it.
All right. Turn that volume down ain't gonna help. Turn the volume on. He said he could do it. So who's still getting feedback?
I didn't hear any feedback. Who said we have feedback?
Since I turned the volume back on.
I didn't know anybody adjusted the volume after we had adjusted the volume.
I did it over here.
Oh yeah. Okay.
I didn't hear the feedback, but I didn't have my headphones up super loud. But I didn't notice the feedback in here
Yeah.
without it.
Cause I can't hear it. I have to come in here and listen to it. That's why the first thing I came to, this here,
Right.
it was doggone super loud.
Well, I think that's because when Mr. Durrett was walking around and coming back and forth to it, he could be heard good. But then when Mr. Burnett was talking, he doesn't talk as loud. And so probably he turned it up while he was talking.
And then up here and out, you remember when I just did this and that went off. What they doing now?
We're in recess right now. Said 10-minute recess and then it's at 2:37.
$300.
Build your courthouse in 1920.
Big times is hard to build it. It's regular court days, that's full.
Probably early 2000s. They redid all this up here and they moved the bench like.
So that blew my theory. My theory was built in 1904, was built for no light, maybe everything's so close so that you could hear each other. But if they really did it in 2000. Actually, he's coming. It's this.
Oh yeah. Well, it's better now. You got a little space.
Now I do like the screen. I've always got to get them to stand up, point to the TV.
Yeah.
Now, we in Washington, they jump wall. That works. I'm used to 16 phone calls.
Hey, did you see my message?
And that's going to be cool. Sweet tea. Yeah, sweet tea.
Okay, all right.
I don't know, Jared. Don't know.
How many rooms
Still
are you
in
building?
midnight for sweet tea.
And there's one small office there.
Sure doesn't have a lot of names on it. Yeah.
What's her name? Right. The one that's not from a judge.
It's her old.
Yeah.
No, it used to be her house.
The law offices of Newby, Rogers, Everett.
That's not right. That's not it.
Well, I don't know who it is, though.
I don't know either. That has nothing to do with me. I don't know who that is.
Well, I just need to make sure they get the right place to send the bill, you know. I'm like, what is that? Like, there's like 5 names on that, and yours isn't even one of them. Like, what is that all about? I didn't either.
Not me.
I'm like, what is it? Whatever. I have no idea, but I need to let them know that that's not the right place. It may be some other person in the form or something.
Oh, goodness.
Went from a man in a tree to
You wanna call me few times coming in and out, they go in order. And then when you come out, you don't have to climb over each other. So just a thought. Now you should raise your right hand, please. You solemnly swear the testimony about giving this cause will give the truth, the whole truth, and nothing but the truth. So help you God. Yes. Thank you. You may be seated. And you may inquire.
Thank you. Good afternoon to you.
Yes, sir.
Will you please tell the jury who you are and what you do for a living?
My name is Ryan Young. I am a lieutenant with the Eunice, Louisiana Police Department. I've been there for about 27 years.
And Lieutenant, we're here today discussing a case, State of Florida versus Christopher Cambron. And did you have any interaction yourself in Louisiana with Mr. Cambron?
I did.
And where did you interact with Mr. Cambron?
At his residence in Eunice.
And what was the purpose of you going to Mr. Cambron's residence in Eunice to interact with him?
I was contacted by an agent with the Florida Department of Law Enforcement back in February of this year, actually February 23rd of this year. He had contacted the Eunice Police Department via telephone. I spoke to him and he subsequently sent me an email asking me to make contact with Mr. Christopher Cambron at his residence, and he provided me with the residence. He also provided me with a description of the vehicle that was possibly at the residence, along with a license plate number.
So, and the purpose that the Florida Department of Law Enforcement agent reached out to you to then in turn ask you to communicate with Mr. Cambron, was that to discuss a video that had been observed?
Yes, he stated that Mr. Cambron was suspected of making a video that was displayed on his wife's TikTok account. And in the email, he stated that one of the other agents had identified Mr. Cambron's voice, but asked me to conduct an interview to see if he would admit to making that video.
And so you actually traveled to Mr. Cambron's residence and spoke with him about the video?
I did.
And when you're on duty, do you wear a body camera?
My primary duty is I am a homicide detective and violent crimes detective. I don't normally wear the camera during my day-to-day activities unless I'm going out in the field. And at that point, I knew I was going out in the field, so I did wear the body camera.
And so is the entire interaction between yourself and Mr. Cambron, was it recorded on your body-worn camera?
Yes, it was.
And, Your Honor, at this time, I'd like to offer into evidence what's marked ID States 3 as States Exhibit 3, which is a recorded interview of Christopher Cambron by Ryan Young.
Any objection, Judge?
No objection.
No objection? We would agree to it, yes. All right, number 3 is admitted.
And we would request, Your Honor, prior to publishing, if Your Honor would provide the brief instruction on edited recording. I believe it is instruction 2.2.
Members of the jury are about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider the evidence. You may publish it. Yes.
Thank you, Judge.
Today's date is February 26, 2024. The time currently is 9:36 a.m. My name is Lieutenant Ryan Young. I am an investigator with the Eunice Police Department. Close. I was provided an address of 167 Veterans Drive in Eunice, Louisiana. and I am currently en route to that location. The location is a brick home, white metal roof. In the driveway is a blue Nissan Versa, Louisiana license info 125 Echo Echo Zulu. I'm now going to attempt to make contact with Mr. Cameron. 307 headquarters, down at 167 Veterans Drive, Signal 54. Good morning. How you doing?
Good, how's it going?
Good. You Mr. Cameron?
Yeah.
I'm Lieutenant Ryan Young. I work for the city of Eunice. You have a few minutes to talk to me?
Yeah, let me throw some clothes on.
Sure, no problem. Contact established. 65. Hey, how you doing? I'm sorry to wake you up. I get up early in the morning, so it's second nature, I think.
I stay up real late. I stay up most of the night.
Oh, you're a night owl?
Oh, I wish I was, and I wish I could go to sleep. In fact, that's not good for your health to stay up at night.
I'm usually in bed by 9 o'clock.
I should have thrown some better pants on you.
Ah, that's fine.
Mr. Lieutenant, sir.
Yes, sir. So the reason I came to speak with you, not first of all, you're not in any kind of trouble. I don't have any warrants or anything like that. I just want to talk to you. And I have a lot of free time, and I came across a TikTok video that kind of, I don't know if you're a gamer, I don't know what.
I make films. The FBI's, they got a YouTube video where the FBI came and was talking to me about my films, and I was like, when I was 8 years old, I was making movies with my brother's 8mm video on my father's camera.
Okay.
And this is all on YouTube too. I filmed it. I came and going, and the guy came over my house. This was like 10 years ago. And so they put a bulletin on me saying about every one of my videos, this is what he's saying this, and he's saying this. And people are telling me to think. But these are films. I'm making movies that are to inspire, you know, what they do, fear and you know, thriller type science fiction type things like that.
Okay.
So that's what it is about. But I can see why nowadays, in today's environment, why people are being visited and asked about their videos and stuff. But it's not a video. It's in a video form, but it's in the film. And also it says in the bulletin that I was on social media. I've never been on social media unless people are calling YouTube social media, but I use it as a broadcast.
Yeah, and I mean, pretty much anything these days, you know, Facebook, YouTube, TikTok, Instagram, they all consider that social media. You know, even MySpace back in the day was social media, socializing with others. And I didn't see any other videos. I mean, the one I saw, I was like, it struck me a little funny about the one that it was a Patriot. It was called the Patriot.
That's my new cartoon I'm coming up with. The Patriot, where his nemesis are judges. He attacks and he executes. Well, you've seen the thing.
Well, yeah, I read it and I watched it, and
I got a response from my son's friends. They watched it too, and thought that was something. They couldn't talk after they viewed it. They couldn't speak. They didn't speak. The married couple. They couldn't speak after they saw that one.
Right. Yeah. Now, are these the characters in your films? Are they fictional characters or are they?
Yeah.
Okay.
It's all made up. Like when I did a vampire movie when I was a kid, a werewolf. I did a police detective with rock and roll when I was a teenager. I did that before Miami Vice. Miami Vice used music and integrated it into their show. I did that with way before Miami Vice did it when I was a little kid and did a movie like that. But they're little short films, like movies used to be done. No, Brenda, take that away. No camera. I'm a little camera, so I did a camera film.
I mean,
where do you got film?
Yeah.
No, I know you don't mind that. I don't need that. I don't need to be filmed.
I mean, it just, you know, with all the different things going on in the world, especially with these school shootings and stuff, a lot of people post these videos and they say things and then they come to light, you know? And in that particular video, you made a reference about executing Judge Johnson, you know? And is Judge Johnson a fictional character?
Well, yeah, in this book that it is, but it's all based on reality. It's based on the reality of abducting children. Because I homeschooled 3 doctors, you know. No tattoos, no piercings, no criminal record.
I mean, piercings and tattoos I got tattoos, I mean.
It just shows, it's by the psychiatry, the medical field calls it self-hurting. It's, I don't know the words, I'm sorry, I'm ignorant, I'm not a doctor. But it's it's anything where you're hurting yourself.
Like mutilation, self-mutilation.
That's it, sir. Yes, sir.
Hey, good morning, how are you? Sorry to wake you up, I apologize for that. I'm Lieutenant Young, I work for the Eunice Police Department. And like I was explaining to you, I came across a video on your TikTok. And I watched it and I was like a little concerned about the Patriot. But he's explaining to me that he makes these these films. And
I did make one documentary when I mentioned that. It was about Obama
And I think that's when the trouble started, when the bulletin started.
Well, pretty much anytime you mention the president and, you know, people.
We call Dr. Berry stupidly, and I just use his own words throughout the thing, because he said that about the police. He said the police acted stupid a long time ago. I don't know if you remember.
Oh, police do act stupid sometimes. I'll be the first to admit, you know.
I said it, but he said they acted stupid with some case with his friend, the professor. They went in his house, and that's why I said, well, I'm going to title the documentary that stupidly. But that's what they are, they're fiction, and they're meant to be exciting, they're meant to be shocking to get the attention, but they're not getting the attention. I see Kitty gets 1 million views, and I only get 12 views. She goes on there, she got 2,000 views just talking. So there's no sense to try to.
Well, you know, and like I say,
I can't get the numbers, but no, it's not based on anything.
my job is to generally protect the public, everybody, you know, whether it be y'all, whether it be the man and the woman across the street, everyone. And I have to look into different things. When I get if somebody says, hey, there's going to be a bomb threat, or there's a bomb threat at Walmart, you know, because we get those all the time. And we know 99.9% of the time it's going to be a bunch of BS, but we have to at least go, we have to check it out, you know, and being that y'all are living here in the city of Eunice, with that, and that raised my eyebrows. I was like, you know, I've never met this man, I've never heard about this man before, I don't know this man, it's not a name from around here, so let me go talk to him, find out.
My son's a doctor. We just came here to live close to him. He's about a few minutes down the medical center over there. We homeschooled 3 doctors, and then,
then you ran for sheriff.
And I ran for sheriff and all things with the all got crooked sheriff.
And then comes to find out, like, years.
That's why I ran for sheriff. We just moved there and found out all these people didn't like them. So I said, well, I like to run for offices here and there.
And now the state attorney over there and the county attorney are both in prison for crimes committed about the same time period that crimes were committed against us.
And I asked to sit on one of my films after Joe Biden. I said it twice. He was going
2015.
2015, and that's when things really went down.
Yes.
But now, you know, half the country's saying after Joe Biden. But,
well, I don't necessarily agree with all his decisions, but, you know, I'm not in a position to run for the president of the United States. To change it is, you know, politics is not my thing. So, but
I should stay away from it. I should stay away from it. My mom says 2 things you don't talk about: politics and religion. I said to her when I was a kid, those are the most important things. Talk about those are 2 things to stay away from. She's right, and she's so smart.
Yeah, I mean, I get it, but a lot of people have different views, especially with religion and politics. And with the best boat motor is, but you know, there's always going to be somebody to debate against you. But well, I won't take up much more of your time. I just wanted to kind of touch base with you. You know, that video kind of was like, okay, is this somebody who's really, you know,
you're comfortable that you come by anytime. Guns, nothing. We don't have any guns. We don't even have a crossbow. I was thinking of giving you one, but now my dad here just rip this peak off.
Yeah, they're pretty powerful. If you don't know what you're doing with them, that definitely hurts you. But again, I'm sorry to wake y'all up. And I mean, it's you know, 10 o'clock. It's almost lunchtime for me. So, but I appreciate it. Thank you very much.
Thank you, sir.
Yes, sir.
All right.
The time currently is 9:54 p.m. Excuse me, 9:54 a.m. February 26, 2024. Again, I am Lieutenant Ryan Young of the Eunice Police Department.
Lieutenant, the man we just saw you interacting with and on that video, is that person here in the courtroom today?
Yes, sir.
Can you tell us where he's seated and what he's wearing?
The defendant sitting with counsel there that raised his hand.
Raising his hand. Your Honor, we ask the record reflect the witnesses identified.
Any objection? No objection. Give him some reflect.
No further questions, Your Honor. Tenor for cross.
Cross-examine.
Brian Young, correct?
Correct.
27 or 28 years?
Sorry?
27 or 28 years with the police department there?
27. I started my 27th year in September.
And you came here today, did you fly or did you drive?
I drove 600 miles.
600 miles.
Yes, sir.
Quite a trek, eh?
Yes, sir.
Okay. I'm here to ask you a couple questions about the interview that you had with Mr. Cambrone. That was his wife sitting there behind him, correct?
Sir?
That was his wife, Brenda, there in the photo,
Yes.
correct? All right. Now, I just want to ask you a little bit about, you know, at this time, when you came out there, you would consider that a non-custodial interview, correct?
I'm sorry, I'm hard of hearing and I can't quite.
You would consider that a non-custodial interview, correct?
Yes, sir.
Okay. And it didn't appear, you didn't bring out your gun or anything, you didn't feel threatened or anything like that at that time, correct?
No, sir.
Okay. Now, my understanding is that you spoke to a Officer Perez, is that not correct?
Mr. Lawrence Perez.
Right. And he gave you specific information concerning Mr. Cambrone, correct?
Correct.
Okay. So he was wanting you to basically find out if he was the author or the voice that was on the video, the previous video, correct?
Correct. He wanted me to conduct an interview to verify that he had made the video.
Okay. And it was your understanding that that video actually went up on social media in September of 2023, correct?
I'm not sure when it was posted, but in his email, he posted a link to the video, which I watched prior to my interaction with Mr. Cambrone.
So would it not surprise you that it went up in September 2023?
I'm not going to speculate when it went up. It's February whenever I had the interaction with Mr. Perez, and it was February 23rd when I watched the video. So I have no idea when it went up.
And that would have been of 2024, correct?
Correct.
Okay. Now, did you have opportunity to question anybody as to who else was present in that home or who else lived there or anything?
No, I didn't ask who else was in the home.
So do you know if there was any persons other than Mr. Cambrone and his wife that resided at that home?
I don't know if anyone else was in that home.
Okay. And do you have any idea whether you weren't asked to find out who had access to the computer and all that was the video of the Patreon or Patriot was posted? That you weren't asked to inquire as to that.
Once I began my conversation with him and he admitted that he made the video, my obligation to Mr. Perez was
completed.
And I did not ask him if anyone else in the residence had access to the computer.
Okay, so he didn't ask you to find out who actually posted the video, correct?
No, sir. I actually have the email from Mr. Perez that wanted to know if he was the one that made the video.
All right. And so at this point in time, you don't have the ability to state beyond a reasonable doubt who actually posted that video, do you?
Objection, Your Honor. He's invading the province of the jury with that question.
Sustained.
What did you say?
Sustained.
Okay. So at this point in time, you know that he admitted to you that he was the one that made the video, but you have no idea who actually uploaded it, correct?
I know that it was uploaded on his wife's TikTok account.
Okay.
Physically by who, I do not know.
Okay, all right, thank you, sir. And during that period of time, did he not say to something to the effect that the video was made for, like, teaching, something of that nature? Was that what you understood that he said?
He said, if I recall correctly, again, I'm somewhat hard of hearing. I'm a firearms instructor, so I'm around a lot of gunfire. And he does babble somewhat in his speaking, but I do recall him saying something about shock.
Shock?
Like his videos were for shock.
But you don't recall whether he said they were for teaching or educational purposes or anything like that?
I don't recall.
Okay. And were you aware of no one informed you whether or not anything other than the posting of video took place between Mr. Cambron and Judge Johnson or Judge Fiegel from September to February? No one ever informed you
No,
that?
sir. After I concluded this interview, I sent a copy of the recording back to Mr. Perez.
And then that was it until we started subpoenaing
Until I
you?
was later contacted by Mr. Perez with a order of, if I'm saying it right, capias, basically a warrant to take him into custody.
All right. All right. Well, thank you for traveling here today, sir. Appreciate you taking time.
Yes, sir.
Thank you.
All right, you need to read
Briefly, Judge. And in that same video interview we just watched, please correct me if I'm wrong, but didn't Mr. Cambron say in that very video to you how he's shown this to other people, this video?
Yes.
And when he's talking about it being for teaching, didn't he also say in that video that he's making movies that are to inspire fear?
Yes.
Okay.
Shock, fear.
I don't have any other questions.
Thank you.
Yes, sir.
Can he be excused?
Yes, sir. He can be excused. I don't know that I think he may be leaving tomorrow, but we're not going to have to recall him now.
I just want one question to follow up.
Sure.
Okay, go ahead.
You can stay standing. When he said install fear, did you know if he was saying fear as to the imaginary judge or install fear to students and people as to the government?
I can't state exactly what his fear intentions were, but his way of thinking is definitely different than my way of thinking.
Okay, all right, thank you.
Any follow-up?
No, sir.
Any objection to him being excused?
No objection, Judge.
You're free to go. Thank you, sir.
Thank you for driving up.
Our next witness?
Your Honor, at this point, the state would announce arrest.
Stand down, having arrested, defense ready to proceed, or do you have a motion to?
We would have a motion, Judge.
Is it gonna be lengthy?
5 minutes. 3 minutes.
Three. All right. Counsel approach the bench then, please.
So we want to do this here? All right. Just a motion for judgment of acquittal, Judge. Insufficient evidence produced as to meet all the elements. You remember we were talking before, we were talking about jury instructions, the different elements. One of those elements is that they have to prove and show some evidence that shows that it was not just created by Mr. Cambron, that it was, in addition to being created, uploaded, or put into social media context of some sort by Mr. Cambron, or caused to have been put into a social media context, specifically Brenda Cambron's TikTok account in this case, because that's the very clear evidence that we have from our first witness and our second witness, is that we're talking about really Brenda Cambron's TikTok account. And so they have to prove, they have to show, not just by implication or inference, but they have to actually show that that's the case. So it's the posting of the video fill in the holes for the prosecution's failure.
All right, State?
Your Honor, I think, sorry, Judge. In a light most favorable to the state, Your Honor, we have presented evidence that Mr. Cambron created the video. In his statement to Lieutenant Young, he indicated that he had shown the video to other persons, friends, family. Additionally, he spoke as to his wife's TikTok account getting more views than him. He also spoke as to how he creates these videos to instill fear. And yeah, that, I mean, inherently, one is creating a film to inspire someone and to instill something. One's producing or publishing it, transmitting it, but by his own words, he's indicating that he has done that. And we think in a light most favorable to the state, it should be denied.
Okay, and your response?
Yes, he did say those things in the video, but what he didn't say was that he uploaded it. And that's the element of proof that's required, is that they have to be able to show that he uploaded it to Brenda Cambron's TikTok account, and they can't show that. I get that they're trying to, I don't know, imply it, infer it from some other language, but that's just not what was said. It's just not the words that were used. He did talk about other things, but other things are other things. And this is a very specific requirement in the jury instruction in the statute. So.
All right, the court finds or denies the motion for the judgment of acquittal. I do find that he admitted to creating it. He had certainly had the motive, be the one to have the motive to produce it and upload it or have it uploaded. He indicated that his wife got more views as a result, so obviously he was aware of it. His wife being a resident of the same home, it's certainly a implication that the jury can make that he was instrumental in posting it, publishing it, or delivering it. And in addition, he said he did so to, and his intent was to show fear. So for those reasons, coupled with all the other evidence, the court does find that there's a prima facie case in light most favorable to the state as to that element, and the motion for judgment of acquittal must be denied. And how did you want to proceed now?
We're going to rest, Judge.
You're not going to call any witnesses?
Not going to call any
So we need to
witnesses.
have a colloquy basically with your client as to his decision not to testify. We
Yes.
can do that in chambers, and we'll go over jury instructions as well. Okay?
Yeah. All right.
All right, state now having rested, defense ready to proceed?
The defense rests as well, Judge.
Okay. Members of the jury, both the state and defense have now rested their case. What is left for all of us is, first of all, to have a conference, a matter of law that needs to be addressed outside your presence, and that's probably going to take about 15 minutes or so. We'll do that in chambers while you all are on a recess. When we reconvene, then I'll instruct you on the law, and then we'll hear the final argument from the lawyers. And it is about 3:35. It's going to get us close to 4 o'clock probably by the time we reconvene. So keep in mind, I don't know how long the final arguments will be, but I'll discuss that with the attorneys during the recess as well. And I say all that to say this: the jury instructions are probably going to take me 20 minutes to read for you, and we'll find out how long the attorneys want to take for their final arguments. So we'll figure all that out when we come back here, and then decide whether you want to push on today to finish the case or come back in the morning. Okay, so, and I typically let that decision be made by all of you by majority. So be considering that as well in your recess. All right. Okay, we will be in recess. Jury will be in recess until 4 o'clock. And when you do return, go into the jury room. Remember the instructions I've given you will continue to apply, and leave your notepads here. And I'll see counsel and the defendant, clerk and court reporter in chambers in 5 minutes.
Yes, sir.
Court will be in recess. If you would bring your set of instructions to jury instructions.
Mrs. Conrad. Johnny, please. What's up? Yeah. And my computer is back there because I've got to have instructions on how to do things. and I want to amend
You wanted to put something in about like mens rea or
this,
something.
yeah. The, as to number 4, the intended, the threat to be a true threat,
I'm just
or
thinking
if
of where to
it's,
stick language.
I'm saying, we can do it in here, but I'm asking if we to add it in 3.2 to say defendant intended the threat to be a true threat or a reasonably cautious and prudent person would view it as a true threat, something like that. That makes sense?
Yeah, all right. Yeah, that makes sense.
We'll knock it out back there with that.
Yeah, okay.
Yeah, they're up for closing, so they give them the case at probably 4:40. My preference is to be done.
I do like the idea of people first thing in the morning about what I'm getting.
Oh, yeah.
Find out when then he's gonna come back, this, that, and the other. We gotta try to get a lawyer until the prosecution's passed. Since he's in the middle of
The guy I was talking about this is one of the guys in which tells you that I'm optimistic.
Better get there, buddy.
It is wonderful. He gets this people that say they need cheese. Every Friday, the guys are doing it since.
I got you. I hear the car blocker. What I do, what I tell my wife, I say, that's fine, we'll eat a piece of cake. And I said, we'll just have to like Bill Carson. When he got to be a coach like the Patriots, he wanted to eat a 3 Musketeer bar. He said, but if I'm gonna do it, I'm gonna turn the treadmill on and walk while I do it and put a slight incline. He should sit there for like, yeah, I've got to walk for 30 minutes if I want to eat this 3 Musketeer. But he can do it. And that's what I tell her. I said, if we're gonna eat it, then we're just gonna have to run a little further in the morning. Yeah, I hear you. I've gotten
I kid you not. Really not.
It's good talking to Judge. That's yours. I'm hooked up back there. Yeah, we're about to discuss the, changes for that medical
Which you're gonna print us a copy too, right? Of the whole thing? Just a copy of the jury. I want the verdict and the elements, the only two things. I'll go over those two things with them.
chambers, and the record will reflect the defendant's present as well. And I just wanted to make sure, Mr. Cambron, you remain under oath. Your lawyer has advised the court that you do not wish to give testimony in this case. Is that correct?
Yes, sir.
And the decision, as I told you before, is your decision. And I want to make sure that no one has forced you into this decision or promised you anything.
No, sir.
It's your decision solely, and you've had sufficient time to consider it and discuss it with your lawyers.
Yes, sir.
All right, and as I told you before, since your decision is not to testify, I'll give the jury an instruction, if you wish, that they're not to consider that as any proof of guilt. Knowing all that, you still confirm that you do not wish to testify in the case.
No, I do not wish to testify, sir.
Okay, and that's your decision, is that correct?
Yes, yes, sir.
Okay, and have you continued to be well satisfied with the services your lawyers have provided to you in this matter?
Yes, sir.
They've done what you asked them to do?
Yes, sir, they have.
Okay. All right, since both of you have rested, let's go through the jury instructions, and as proposed, I've got a set here. Do you have yours with you? Okay.
Mine's on the table out there, but I can listen.
All right. Court will give 3.1, the introduction to the final instructions, 3.2, statement of the charge, 8.22, written or electronic threats to kill, and the 4 elements and the definitions underneath. That's a standard, correct? Everybody?
It is, Judge, and this one here, and I was talking to Mr. Burnett because they have a proposed instruction they want included as it relates to First Amendment.
Okay.
And as a back and forth about that, I said, well, I would agree to that. If we agree that element 4 here to be amended to read, the defendant intended the threat to be a true threat or a reasonably cautious and prudent person would view it as a true threat.
Okay, or a reasonably, say it again, a reasonably
Cautious and prudent person.
Cautious
and I can add it in here, Judge.
Okay, person would consider it as such, as I'm just saying.
A reasonably cautious and prudent person would consider it a true threat.
Would. Is that agreed?
Yes, Judge.
Okay, so that language will be added to number 4.
Yes.
All right, and then the definitions of a true threat, procure, and other record will be given. And since you're amending that or correcting it, if you could put the defendant's name into the elements, the 4 elements as well.
Yes, sir.
Okay. And then court will give 3.7, that's standard plea of not guilty, reasonable doubt, burden of proof. Weighing the evidence, 3.9. First 5 will be given. I assume 6 would not be given. Is that agreed? There hasn't been any preferred treatment or preference or money to testify.
Correct.
That'll be removed from number 6. 7, pressure or threat used against a witness to give testimony, that's not applicable. 7 will not be given. Inconsistent statement. I don't recall any. Were there any? Maybe.
Yeah, maybe.
I don't have an issue with it being given if they want to argue as to an inconsistency.
We'll give that. That'll be number 6.
Okay.
No conviction of a felony or misdemeanor. That won't be given, and no reputation. So 1 through 5, and then number 8 will become number 6. Agreed?
Yes, sir.
Yes, Judge.
Okay. And then the rest is standard. You want the paragraph about the defendant not testifying?
I do, Judge.
I'm taking out the give only
One
defendant
word.
testify.
Okay, that comes out.
Yes,
Then we'll go to the defendant not testifying. That's 3.9A. Both paragraphs you wish given?
I do, Judge.
Okay. 3.9A will be given. 3.9B, defendant statements. You want that given? I'm not sure that's applicable here, but if you want it given, I'll give it.
I don't think it's applicable.
If it's not requested by defense, I don't care for it.
You don't want it either, so that'll be removed, correct?
I think that's correct, Judge.
Okay, that will not be given. Rules for deliberation, 3.10, that'll be given. In its entirety, and then 3.11, the cautionary instruction, the verdict, 3.12. I don't believe the second paragraph should be given as proposed here. Should just be, you should find the defendant guilty as charged or not guilty. There's no lesser offense.
I agree.
Okay,
Yes,
so that
sir.
paragraph should be removed, and then the third paragraph must be unanimous. That should be given. Agreed?
Yes, Judge.
So just those two paragraphs, we can remove the second one.
Yes, sir. Done.
All right, then the court will give the instruction as to final argument, which is 2.7. And then once you're finished with your arguments, the court will give 3.13, submitting the case to the jury. And I'll read the verdict form after 3.12, and I understand we've reached an agreement on the form of verdict, which is two choices: the defendant's guilty of written or electronic threat to kill as charged, and B is not guilty. Agreed?
Yes, Judge.
To the form of verdict. All right. Now, as to the length of your final argument, state.
Hey, Judge, there's the First Amendment.
Oh, you want that given in addition?
Yeah, and that's part of our agreement, and so I'm not sure exactly where we want to stick that.
All right.
Perhaps after the primary charge about the crime itself.
I'd be fine with that, right after 822, after we're reading the charge itself.
Shouldn't it say he made a threat to kill and he procured to have it posted? I mean, that's what
That's what, you know, the charge.
it's not just that he made a threat to kill, it's he made a threat to kill and he published it, or he procured someone to publish.
It
It's
says
in the
sent,
standard.
posted, or transmitted,
Or
procured.
Or
Procured, the sending, posted.
Okay, all right,
It's
that's,
in there.
cause it's two acts that have to be complete.
That's number two. Yeah, that's element 2.
All right, that's fine with me.
All right, and then the special instruction on the First Amendment, you're agreeing that be given?
I have no issue with it.
No.
In light of the discussion as it relates to the amendment to
Number
4, as we
Okay.
did.
Let me read through it here.
Maybe the fan motor on the condenser out there.
I think it's a band. They need some practice, don't they?
Indeed.
Okay. Now, do you want we don't need the source on the instruction that goes to the jury, agreed?
That's agreed.
Okay,
Yes,
so
sir.
that'll be removed.
I don't have I got it in a PDF, so I have a way.
There's a source at the bottom of the page. It's just.
It just says source and it cites 2 cases.
Oh, yes, sir. Yes, sir. I was just saying, I don't have the ability to edit it.
Yeah, just case language.
And then we've got given or refused. Is this on some,
It's off a federal form.
is this a document you can email,
I don't have the ability to do that.
to email it?
I can't.
I have just the PDF. I'm fine if we,
You have it in a PDF,
yes, sir.
so you can't alter it.
Not beyond my abilities.
All right, and then I'll remove the bottom portion, and I'll just get my JA to copy this and just cover it up, so we're not seeing it out. And do you want the instruction number? Do you want to have it numbered, or just leave that out?
It may, to the degree that it helps you insert it in the right place, I think that's really the only purpose for that.
Okay. I can number it if you want.
I can leave a blank page in this these fixed, the numbers on them. And y'all just write it on that one.
I'll just instruction number. I'll just make it 8.3, and that'll fit in after the 8.2. How about that? We'll make it 8.3 special instruction. Special instruction 8.3 First Amendment, and I'll read it as in its entirety, omitting the source and the given or refused, and then the caption down at the bottom.
Judge, if you want to have it labeled as page 3, I've got it now with,
Well, don't make it page 3 because we should have a page 3 somewhere. Let's just make it 6A.
okay.
Page
I was
6A
redoing them. I took out all the 2s. I can put them back.
Took out all the 2s.
Like the preliminary, the instruction on edited recordings, everything you've already given. Do you want them back in there, Judge?
No, not necessarily, but I'm just gonna start on page 6.
Yes, sir.
What you had is page 6, which is the 3.1. And then just, can you change the number on the defense instruction?
I can, where I've got it pulled up now, I've taken out all the 2.1, 2.2, 2.7, all that, and it would just start with, page 1 is that cover sheet, and then page 2 would be the introduction, and then it would define the crime charged, and then I could leave page 3 blank to insert their special instruction. Then we'd pick up page 4, plea of not guilty, and there'd be 9 total pages in all.
That's fine.
Yes.
Okay, but I'll take this as it is here and just have my secretary copy it. Just cover this up and then copy it.
That's fine.
Is that okay with everybody? Okay with you, Mr. Durrett?
Yes, sir.
Just where I got it scratched out, I'll have her copy this and cover it up and then copy the whole thing, and that's what it'll look.
Yes, sir. And
Can you ask Millie to do that for me? Thank
I'm
you.
printing these now.
Read my mind, doesn't she?
Judges, it's kind of a modification of the federal jury instruction.
Okay. Yeah, you'll just ask her to cover those parts I'd scratched out and then copy it. Thank you.
As to time, Your Honor, Mr. Thomas is gonna be handling the first part. He can talk as long as you let him, but I think will,
5 minutes?
I think he said probably, 20 would be, sufficient for him.
All right, let me get to that page here. 20 for him. And how long for you?
In a rebuttal, it depends. I mean, probably no more than 10.
How long is your final argument?
It will be exactly how long the two of them together are. 30 minutes.
30? Can you agree to 30?
I can agree to 30.
Can you agree to
Yes, sir.
30 total?
I will tell him, get it done.
Tell him to get it done, so we'll limit each, I'll tell the jury each of you have 30 minutes. To give your final.
If he
total
takes
argument.
25, I'll take 5.
Okay, that's agreed. So that'll be an hour plus the instructions. By the time we get out there, it's gonna be probably 10 after 4. That's an hour and 20 minutes with a recess. Probably it's gonna be close to 5:45 probably by the time the jury gets it if we go straight through. So I'm gonna tell them that and then let them make a decision if they wanna hear all this today or if they wanna come back tomorrow. Fair enough?
You gonna send them back for at least an hour or so, or after we do all the instructions, you're going to let them decide?
No, when we go back out there, I'm gonna tell them that what is left is gonna take about an hour and a half or so.
Right.
And then that means if we go straight through with one recess, that'll get us close to 6 before they go back to deliberate, if we went through today. Or we can take a recess now, come back in the morning, I'll give them the instructions, and then you can do your final arguments in the morning.
Oh, okay. So we'll do it all tomorrow,
No
basically.
sense going late today if we're gonna come back tomorrow. If
That's
they wanna
fine.
go late today, that's fine with me, but it'll be their choice. So they can't get mad at
As
themselves.
long as they don't get mad at me.
As long as they don't get mad at themselves.
So I got my stuff canceled and backing up tomorrow. The other side filed it. I was waiting the last minute to see if they filed the continuance. So
And
I
they
would
did?
have to
You
explain.
held them out?
Huh?
You held out long enough?
Yeah, I didn't wanna get a custody case continued and me file a motion. So the other lawyer waited till the 11th hour and he filed it, so I don't look bad for my client.
Where'd you go to law school?
St. Thomas Catholic Law School.
Yeah, way down in Miami down that way. Right?
Yeah, I was down there a week or so ago. A friend of mine is the lawyer for a nonprofit with cancer, and they had a big old thing at the Hard Rock. That place is incredible, right there in Cinema.
Yeah, I've heard of it. I've seen it.
$800 million they paid. I mean, it's like.
Where'd you go to law school?
Cumberland School of Law.
Me too.
Birmingham.
Me too.
You went to Cumberland?
I went to
So
Cumberland.
you're not an Alabama fan?
Not a no.
Oh, man.
When did you go?
That's
I
like where the
graduated
guy
in
that trained me went to Cumberland. So a bunch of people in Pensacola went to Cumberland. It's,
Oh, yeah.
it's,
I had a
it's,
lot of classmates from there. I graduated in '84.
Okay, yeah, it's 5 years ahead of me, so well, we went there so long ago that they actually had smoking in the hallways and all that kind of stuff.
Oh, yeah.
And of course, that was granted, taken in a hostile way by the Baptist, you know.
Oh, yeah.
running
Everything
Sanford.
was taken in a hospital.
Exactly.
By the university.
Oh, yeah.
yeah.
Absolutely.
The lawyer.
Where'd you go to undergrad?
Alabama.
I went to Troy.
Okay, yeah, I got a sister went to Troy.
I started at Florida, but ended up in Troy.
So you went to Florida
University
undergrad?
of Florida undergrad for a couple of years.
Yeah.
Figured I wanted to go home and mow the lawns for a living until I went through a summer of doing that.
Mowing
And I decided
lawns.
I'm going back to college.
Yeah.
So I went to Troy then
Okay.
Yeah.
and
My
finished
brother
there.
was there for a little while. Did you see where they were building that? They named a liquor for Alabama to have a state liquor,
No.
and now they're building a distillery and all, and it's supposed to employ like 800 people up in Troy, okay? It's gonna be like an 8,500 square foot complex. I was doing a case up there a while back, and I was
They were
just,
building it?
yeah, look it up, Alabama State Liquor. They're gonna actually have a big, I know it's over 20 acres, but they are making, they had a contest, who had the best moonshine. And then, no, seriously, and they
I remember.
picked this guy that made moonshine with green apples or whatever, and they named that the Alabama State Liquor, and now they're building it and planning to
In Troy.
import it outside the
We
country.
got enough problems.
It was
Well,
very
when
interesting.
my
We need more
fraternity
detail.
brothers find out about that, they'll probably move back to Troy.
Yeah, well, there wasn't, when my brother went there, it was a dry county.
Yeah, it was dry when
He
I was
went there in
too.
like 1981 or 82 or whatnot.
I graduated in
I just thought that was-
79.
I was listening on the way up
Oh,
there.
hold on.
I'm always listening to NPR,
Mhm.
and then I drove past where they were actually getting ready to build. I think it's great. You're gonna have jobs. at
Sure.
least.
Absolutely.
What year did you graduate from law school?
Me?
Yeah.
89. He just said 89. The other guy, Burnett, was 89.
Yeah.
I was
He probably went to,
84.
he went to law school with a good friend of mine.
Did he?
He went to,
At Cumberland?
no, he went to, no, this guy here.
Oh,
He went to
he
St.
went to
Thomas.
St. Thomas, yeah.
Come back in the morning. Well, if you need to go. You got court. Well, you got court with him. You got a big done. You need him stuff here. You need to be doing that. I know. First. Yes, sir.
was like, right here, my being so perfect, yeah. You know, I took, he takes tomorrow, there's a 40-minute drive.
Oh, I do that. I get a 3 every morning. Sometimes I got 3 bits in today, and I'll fire off the message. I tell them, like, you text me after I go to bed. I get you about 9, I'll text you.
I'll do the same. Emails too, I'll send out.
Texted me at 5
I got you. I'll let you sleep till 5 before I text you. I know. I know. I texted Will at 3.
Remain seated, court's back in session.
All right, good to see you, thank you. It works out pretty good, doesn't it? All right, I've discussed the rest of the case with the attorneys. Let me explain to you what's left. I think I told you the instructions and then their final arguments. The instructions will take about 20 minutes for me to read. Both parties have agreed to limit their final arguments to 30 minutes. So that would be an hour and 20 minutes plus a recess. So we're looking at probably an hour and a half, just maybe a little bit longer, before you go back and begin your deliberations. And it's a little after 4, quarter after 4. So that would put us somewhere about 5:45, I would imagine, by the time you go back and deliberate. And I told you earlier that we'd stop no later than 5 o'clock unless it's agreed upon. So the choice is yours, as I indicated, if you want to go forward here today with the rest of the case, understanding that you'll begin your deliberations around 5:45. I can't estimate how long it's going to take for your deliberations. There's no way to guess. It'd be up to you all. So, you got a question?
Now, how long are we allowed to stay if you decide to stay?
We can stay as long as you like.
Okay. And I think we've got a consensus.
Okay, so, yeah, we can stay as long as you want to. And if you get tired and you want to stop and come back tomorrow, we can do that too. Or we can recess now and then start in the morning. So, 2 choices. Continue on now or come back in the morning. Continue on now? Okay. Unanimous vote, so we'll go forward. All right, members of the jury, I want to thank you for your time and attention during this trial. Please pay attention to the instructions on the law that I'm about to give you. Christopher Cameron, the defendant in this case, has been accused of the crime of written or electronic threat to kill. To prove the crime of written or electronic threat to kill, the state must prove the following 4 elements beyond a reasonable doubt. First, that Christopher Cameron made a threat to kill or do bodily harm to another person in writing or other record. Second, Christopher Cameron sent, posted, or transmitted or procured the sending, posting, or transmission of that writing or other record. Third, Christopher Cameron did so in a manner in which it may be viewed by another person. And 4, Christopher Cameron intended the threat to be a true threat, or a reasonably cautious and prudent person would consider it a true threat. I didn't tell you, but the instructions that I'm reading for you now, I'm going to give to you, and you can take them back in the jury room. You're welcome to take notes on the instructions, but they'll go back with you when you do go back to deliberate. A true threat is a serious expression of an intent to commit an act of violence. To procure means to persuade, induce, prevail upon, or cause a person to do something. Other record includes an electronic record. The term electronic record means any record created, modified, archived, received, or distributed electronically, which contains any combination of text, graphic, video, audio, or pictorial represented in a digital form, but does not include a telephone call. In this matter, the defendant, Christopher Paul Cameron, is asserting his First Amendment right of free expression under the United States Constitution. The First Amendment to the United States Constitution in part reads as follows: Congress shall make no law abridging the freedom of speech, and to petition the government for a redress of grievances. The 14th Amendment to the United States Constitution applies this limitation to the states and various subdivisions of states as well. In this matter, the defendant, Christopher Paul Cameron, asserts that his words at issue here were simply crude hyperbole. Crude hyperbole can be defined as an extreme exaggeration that is intended to emphasize a point or convey a feeling, but is not meant to be taken literally. If you believe that the words at issue in this matter are crude hyperbole, then you should find the defendant not guilty. If you believe the defendant is guilty of violating Florida Statute 316.10 and all of its elements beyond a reasonable doubt, then you should find the defendant guilty. Now, the defendant in this case has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, into it alone, that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Now, it's up to you to decide what evidence is reliable. You should use your good common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom to testify. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Now, the Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. the defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. And these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. First, you must follow the law as spelled out in these instructions. If you fail to follow the law, your verdict would be a miscarriage of justice, and there's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Second, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and seen in the form of exhibits in evidence and these instructions. Third, the case must not be decided for or against anyone because you feel sorry for anyone or that you're angry at anyone. And four, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in the case. Fifth, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's my job to determine a proper sentence if the defendant is found guilty. Six, whatever your verdict you must render must be unanimous. That is, each juror must agree to the same verdict. And seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Now, deciding a verdict is exclusively your job, and I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I'd prefer one verdict over another. Now, you may find the defendant guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, which I'll now read for you, understanding that you probably can't see it from where you are, and omitting the caption of the verdict itself. It reads as follows. Verdict of the jury, we the jury find as follows. As to the defendant in this case, it has an instruction in parentheses that says check only one, and you have two choices. Choice A is the defendant is guilty of written or electronic threat to kill as charged in the information. And B reads the defendant is not guilty. So you choose either A or B. And it concludes by saying, so say we all, which confirms this is a unanimous verdict. In other words, a verdict of all of you as well as all of you as an individual, dated at Swanee County, Florida, and today's date, blank for today's date, which is the 18th day of November 2024, and a place for the foreperson to sign, and if you don't mind, print your name under the line as well, whoever is the person. Now, both the state and defendant has now rested their case. The attorneys now will present their final arguments to you. Please remember that what the attorneys say is not evidence nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding this case. Each side will have an equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. All right, state, you may proceed with your final counsel.
May it please the court.
Thank you. You may.
Ladies and gentlemen of the jury, here we are. Very last part. Thank you guys for paying attention, sitting through the evidentiary part. Here's the final argument. So the defendant is charged with a written or electric threat to kill. There are 4 elements. You heard the judge read them. You'll get that packet. And so that's what I'm going to do. I'm going to go over those 4 elements. That's what we have to prove, the state. That's what the state has to prove beyond a reasonable doubt. So the key to this is that you use common sense. That you may not want you to use. Now, your role is the trier of fact, all right? It's not, is he a good person? Is he a bad person? It's not what any punishment should be, anything like that. Your role is, did the state prove these 4 elements? And so we're going to go through the different elements. Christopher Cambron made a threat to kill or do bodily harm to another person in writing or other record. So in any form did he produce something that was a threat to kill. Can we play the video of it?
Yes, sir.
Picture of the great patriot.
Yes, young lady, you may. Just enjoy the picture, enjoy the view of America's patriot who puts bullets in the heads of
That's a good spot.
worse than a Catholic religion. You thought the priests were bad. Wait till
He is the patriot. He's that in the body cam that he is the patriot. That guy right there. Who likes to put bullets in the heads of judges. And guess what? The person that testified is a judge who handled one of his cases. A case back in 2016, as you heard the evidence, that called over and over and over. And as you heard the testimony, remember, testimony did not come from here. Testimony came from there. Right? It's not what any attorney said, it's what was said right here. And you heard Judge Johnson say that it got worse, that it got worse, that it got worse over these 7 years. And then it comes to this, to where now we've got videos coming out saying we put bullets in their head. But to who? Who does he want to kill? Well, let's skip a little bit.
a hold of the Florida child rapist known as Fecal Freak Fegal. And Judge Johnson, who likes to play with little boys Johnson.
Well, you got who his target is. It's Judge Johnson. Who does he want to put a bullet in the head of? Judge Johnson. It's pretty obvious based on the video. In the video, he's stalking someone, walking behind him, saying, "This is Judge Johnson." And you heard in the instructions, they want to talk about some free speech. Yes, but it's limited to a point. No one has the right to ruin someone else's life, put someone else in fear, make someone worry all the time about looking over their shoulder. And that's exactly what's happening right here. Here he is stalking who he claims is the judge.
She makes him cry and she puts in record. She says the children are happy. What should we do?
What should we do?
Well, to stop her from harming any other children, I think it's take down time. Execute the child molester so she doesn't hurt anybody else. Judge Johnson, let's bury the hatchet.
Would any reasonable person who hears their name called out specifically find this to be a threat?
Judge Johnson, you violated the human right. Child molester.
Shot. After
That's
shot.
the end of all child molesting judges.
After
Execution.
Would anybody find that
Patriot
to be a threat? Absolutely. And as you heard in the testimony, it got worse, and it got worse, and it got worse. Now, defense wanted to bring up that it's a threat. Where's the action? Where's the action on a threat? That's what a threat is. It's before the action. No officer pulls up and someone's been shot to pieces on the ground and say, "Look at that threatened guy." Because the threat was already over. They've been killed. We don't wait till somebody's dead. That we have this right here the sending, posting, or transmission of that writing or other record. All right, if you'll play Trump 2, please. So this is from the body cam. Best evidence is the video of the defendant testifying himself.
Fiction, and they're meant to be exciting, they're meant to be shocking to get the attention, but they're not getting the attention. I see Kitty gets 1 million views, and I only get 12 views. She goes on there, she got 2,000 views just talking. So there's no sense to try to.
Well, you know, and like I say,
I can't get the numbers, but no, it's.
I love it when you hear it straight. He said that I don't get as many views. She gets more views. So why is it on her TikTok? Because he wants more views. Why does he want more views? Because he wants this threat out there. He wants people to see this. That's the goal. That's the goal. He is still angry and holding this for 7 years where it's getting worse and it's getting worse and it's getting worse. And now he's putting it out so the rest of the world can see this, hear this. Did he do so in any manner in which it may be viewed by another person? Voila. Look back to the GTA video. Obviously, it can be watched. Doesn't want to watch it.
Yes, young lady.
So this is what was put on TikTok.
Just enjoy the picture.
So
enjoy the.
element 3 absolutely has been put on TikTok. Christopher Cameron, this is part 4. Christopher Cameron intended the threat to be a true threat or a reasonably cautious and prudent person would consider it a true threat. Judge Johnson specifically said, I considered it a threat. To hear her name, and as she said, target number 1. To hear her name on there, hatcheted up, shot up, after all of these years of it getting worse and getting worse and getting worse and getting worse. No one should have to live in fear and look over their shoulder. Is Chris Cameron behind it? And that's what this created. That's what this instilled. Now he tried to say this is a movie. This had no plot. There was no storyline. This was simply rage. And it was a video of making a judge be executed, not just a judge. You heard Judge Jennifer Ellison Johnson. Very specific. The same judge which handled his dependency case back in 2016. She's doing her job, and in that job, makes rulings. Now for the rest of her life, hears these threats. That's what's in front of you today. Did the state prove this? Well, let's hit trial, or just the trial. Shoot the trial. What was his goal? What was he trying?
But these are films. I'm making movies that are to inspire, you know, what they do fear and
I'm making these films to inspire fear. That's what he wanted Judge Johnson to have every single day. And as they said, well, he didn't kill you. No, he didn't kill you. But that's not what we're here for. We're not here for murder. What we're here for is an electronic threat. what you just saw. What he said his entire goal was to push it out there for fear. So that every single day, that's what she sees. That's what she thinks. As she testified to, she is in fear. I believe the First Amendment, powerful amendment that comes with some responsibility. And what every single one of you promised was that you would follow the law. Now, there's a verdict form, the judge showed it to you. Very simple. You have an A or B, you have to mark one. A, the defendant is guilty of a written or electronic threat to kill as charged in the information. I'm asking that you check A. The defendant did exactly that. B, the defendant is not guilty. Put the date, and you'll have a foreperson that will sign on this. Very straightforward. But I don't think there's any doubt. You heard his words. You watched that video. What's in your mind is, would someone take that as a threat? Absolutely. Absolutely. Thank you.
All right, thank you, defense. Ready to proceed?
Thank you, Judge. So first, members of the jury, I just thank you for your time and attention. I remember a couple of years back, even as a lawyer, I got called to jury service. Time consuming, difficult, because I'm a lawyer, I didn't get on any juries. So that was no fun. But it did at least teach me some things about the process that you go through, how you have to go through it, how time consuming it is. So I really appreciate your service and appreciate your time and attention to all this. It's not your business. It's not, you're listening to somebody else's affairs. But you should also know that, for Mr. Cambrone, this is his only shot to get fairness. I mean, if you don't deliver him fairness, nobody else does. I mean, in other words, it's important. When we say it's important what you do, we're not kidding. It's important what you do, all of you. So Mr. Cambrone's only shot at justice and be treated fairly is right here with you. This is where it happens. And so, so we're thankful for your service, thankful for your time and so forth. It has been mentioned more than once that you have to, in terms of analyzing all these elements of the crime that the judge gave you, and it's a good thing that the judge will give you those jury instructions when you go back. So, if you did take notes on them, it doesn't matter, because you're going to have them and you can look at them. All four of those elements, they all have to be proven beyond a reasonable doubt. And so, reasonable doubt is defined in there. Not a small thing. It's important. It's important that we don't just casually take this as something that's, by preponderance of the evidence, in other words, more probable than not. In other words, if you think he probably did it, that's still not guilty, because beyond a reasonable doubt is a higher standard than that. Probably is 51%. More beyond a reasonable doubt, I don't know that we can put a specific number on it, but it is beyond, as the word suggests, beyond any reasonable doubt. We have many reasonable doubts in this matter. We start with, a lot of, I start with it like this just because what they're asking you to do in evaluating this video is they're asking you to enter into the fantasy and believe that the fantasy is somehow real. It's not real. It's fantasy. Everything in that video is a fantasy. He's not a cop. He's not the American Patriot. It's animated. It's not real. You heard the judge from the stand trying very hard to exaggerate what happened. Oh, he hit me in the head with a hatchet. No, he didn't. It's an animation. It's not real. He is frustrated and he's venting and he's upset about what happened in this 2016 dependency yeah, he's venting, and yeah, it's crude hyperbole. Yeah, it's kind of over the top, but none of it is real. It's just not real. And what they're asking you to do is pretend like it is real. You know, he's shooting her with a shotgun. No, he's not. It's not real. It's just not. He didn't shoot her with a shotgun. It's not real. He even says in there, what's going to happen today? It was one of the questions that I asked Judge Johnson, you know, was he says in the video that we're going to execute justice today. We're going to execute, what was the exact language? It was we're going to execute, yeah, we're going to execute some judges to find justice today. Execute them today. Well, that didn't happen. It's just part of the video. It is a performance. You might think it's a stupid performance. You might think it's an awful performance. You might think it's ridiculous and over the top. I kind of agree with all those things. It is ridiculous. It is over the top. It is venting. But even judges can be criticized. Even judges. They are public officials. We criticize public officials all the time. But even judges can be criticized. Judges are not immune from criticism. Not even Judge Johnson is immune from criticism. This video that was shown by Officer Young, in a lot of ways, it's terrific. You get to see, from the video yourself, you get to see, you get to see his demeanor, and you got to see how he was. In terms of his tone and how he talked about it and so forth, he doesn't come off angry, and he doesn't come off enraged, and he doesn't come off as some sort of lunatic. Now, I get that that's the pretense of the prosecution, that he's into all of those things, but you get to see the real deal. You get to see the video, and when he was chit-chatting with the officer, and he had no idea that Officer Young was kind of trying to set him up. Officer Young tells you in the first minute of that video, hey, I've got this call from Florida. They want me to go get this guy. They want me to verify these certain things. That's not what he said to Mr. Cambrone. Mr. Cambrone didn't know all that. All he knew was, hey, I came across this video, okay? And I just wanted to check with you and chat with you about it. Okay. And then he did, and when he talks back and forth with him about it, was there massive amounts of anger, hostility? Did he get all animated? No, none of that. So the guy that they portray as some sort of nut, he chilled out. He's buttoning up his shirt. Just woke him up. He sits on the hood of his car and chit-chats with him. And you see the video. You were asked before, which I think is a terrific idea, to apply common sense. Man, that's a great idea. I hope you do. Common sense tells you the answer to these questions. So let's suppose somebody tells you, man, I'm going to kick your you-know-what. Right? Somebody makes some sort of threat like that. And they make a threat to you like that, and they say that on day one.
Objection, Your Honor. Grounds. Golden rule. Golden rule. Sustained.
Members of the jury, if you apply common sense, you know that when a threat is made and the threat is not followed up on the next day, and the next day, and the next day, and the next day, I could go on. Because you get that this is 8 years times 360 days. That's a lot of next days, and a lot of next days, and a lot of next days. And at some point, common sense tells you that, golly gee whiz, I don't think he meant it. Rational, reasonable, common sense tells you that I don't think he's going to carry out this threat. Now, no matter how awful the video is, 8 years from 2016 to 2024, and the reality is not a fantasy, not something made up, and not some stupid video that he put together to say stupid things or have some crude hyperbole. The reality, the facts common sense suggests that he didn't. He was talking, he's yapping, he's venting, he's full of hot air, you know, fill in the adjectives. He's frustrated. He's frustrated. Even when you read those letters, even they talk about, yeah, you're frustrated. Yeah, but you're not going to talk to the judge. So there is an element here that they have to prove and show having to do with one of the elements that they have to prove. And what one of those elements is that they have to prove and show that it is Mr. Cambrone, not somebody else. It is Mr. Cambrone that posted this to Brenda Cambrone's TikTok account.
Objection, Your Honor, that's not the law.
The court will instruct you on the law. Or has.
To be specific, from the jury instructions, they have to prove that Christopher Cambrone sent, posted, or transmitted, or procured the sending, posting, or transmission of that writing or other record. They have to prove that. Now, in this case, the information doesn't nail it down to just TikTok, but the evidence from the two witnesses specifically says, and we heard from these two witnesses specifically say, that this item, this animation, it's hard not to say video because it's not a video, it's an animation, but anyway, that this animation was uploaded to Brenda Cambrone's TikTok account. Well, they have to prove, because the only evidence, if that's the only video, and that's the one that he's accused of doing, then they have to prove that that was uploaded to TikTok. And it was uploaded by none other than Christopher Cambrone, or that he got somebody to do it or persuaded somebody to do it. They don't have any evidence of that. None. Zip, zilch, zero, nothing. And it is not your job, members of the jury, to fill in the blanks for their failure in evidence. Not your job to do that. You don't have to fill in blanks for what they haven't proved or what they failed to prove, what they failed to show, what they haven't shown. And so that failure in evidence, because there's zip of it, none, they will have to conjure up some sort of implication or inference. They can conjure whatever they like, but they have no evidence of it. They have no evidence that says that Christopher Cambrone uploaded it to TikTok to Brenda Cambrone's 50, to Brenda Cambrone 50. That's her account. That's what Judge Johnson said from the stand. Brenda Cambrone 50. That he did it. They have to prove that he did it or that he had somebody do it for him. And they don't have evidence of that. That's reasonable doubt. Reasonable doubt in regard to that, reasonable doubt in regard to his true intent because of the things that we talked about before. There's one other thing that I would mention about the true intent, because we talked about, you know, a day and a day and a day, and after a while, common sense tells you that it's not a threat, but beyond that, he did very specific things to avoid these people. And, you know, he went 600 miles away, 3 states, he moved 3 states and 600 miles away. That's, and then you add the 8 years to it. So we already talked about the 8 years, but 600 miles? I mean, we heard testimony from Officer Young, how far that guy drove. I mean, I feel for the guy. He had to drive all the way here for this, 9 hours. You know, it's a miserable drive, 600 miles. Christopher Cambrone went out of his way to get away from, you know, Judge Johnson and all this stuff. He went 3 states away. So how authentic is this threat that he has when he's moving way away, wants to be near his son in Louisiana? Seems like a good reason. He was talking about in the video, he talked about how his kid worked down the road at the medical center. He mentioned that. So the other thing I would mention to you is that, you know, the judge even admitted from the stand that she participated in this conference. And in the conference, you got Florida Department of Law Enforcement, you got prosecutor there, and you got 2 judges involved. From the point that happens, I don't think there's really any choice but that this charge was going to be brought. I mean, when the judge tells you to bring a charge, she seemed pretty motivated. You can judge her testimony. She seemed pretty motivated. She's coming up with charges on the stand. But why don't we charge him with stalking? She talks about. She seemed pretty motivated, and given how motivated she is, if she's that motivated in front of the jury on the stand when she's testifying, how motivated is she in private when she's talking to Florida law enforcement and when she's talking to prosecutors? So it seems from that point that there was no choice. Of course they were going to bring this charge. Of course they were going to. They were going to do something because she was, as she put it, irritated, annoyed. She didn't like this guy. She didn't like him questioning her. She didn't like this guy wanting to redress his grievances with her in any way. You know, the analogy that was made earlier, you know, by the prosecutor was that this matter is like screaming fire in a crowded movie theater. I kind of like that analogy to some extent. It's one of those things that all lawyers hear first year of law school. But in this situation, a little bit different. More like having a movie theater that only has about a half dozen people in it, and you point and you have somebody who's pointing up to the screen criticizing the actor on the screen. Because that's more like this actual situation, is that he, Christopher Cambrone, wants to criticize this judge, and the judge will have none of it. That's why it's like the person on the screen. They don't hear what you say. They don't hear anything. And there's no trampling of people getting out of the firehouse at all. He's just kind of a lone voice speaking to the screen, saying crude hyperbole to the screen. Crude hyperbole, that's the First Amendment defense. That is what is actually, I think, most going on here. Crude hyperbole is what the U.S. Supreme Court describes these kinds of situations. They call it crude hyperbole. Hyperbole is just an exaggeration. It is a gross, over-the-top exaggeration. He is over the top in what he says. No doubt about it. Saying things that are unkind, untrue, wrong things, but he's got First Amendment right to say it. That doesn't mean anybody believes it, but he has a right to say it. And so that over-the-top exaggeration is what we have in this situation. He has a right to do that. She could sue him for defamation or something, but that's a different matter. But she didn't want to do that. She wants to bring criminal charge. So in the end, members of the jury, I would absolutely ask you for the verdict in favor of Christopher Cambrone because of the reasonable doubts that we've discussed, because of the time and the day after day after day for 8 years, because of the reasonable doubt having to do with the fact that they can't prove about this posting and so forth, that he posted this particular video. They can't prove that. They can't show that. For that matter, they have difficulty with the third one as well. It says Christopher Cambrone did so in a manner in which it may be viewed by another person. If they can't prove number two, they can't prove number three. In other words, they're connected. They still have to have actual evidence of these things. And so 2 and 3 are connected, the second element and the third element. They can't prove it. It's reasonable doubt. And so beyond all that, there is this idea of the crude hyperbole. That he has this right, like we all do, to engage our First Amendment rights. The First Amendment has these kind of two rights that are different from each other. There is the right that I think everybody knows about, that you have right to free speech, you can say what you like, so forth. That's kind of the most important thing that we know about the First Amendment. The First Amendment also tells us, you know, a little later, and it's in the jury instructions that you'll see, where it says we get to redress our grievances. And the reason I think that's important is because I think that's what he's doing here. He's doing it in a clumsy way. He's not doing it in a way that I would do it, or maybe anybody else would do it, but he's trying to redress his grievances with the person who was at the center of, in his view, wronging him. That's what he's doing. So, members of the jury, yeah, I'd absolutely ask you for a verdict in favor of Christopher Cambron. And so the thing that I would suggest to you, and I mean this, that a verdict in favor of Christopher Cambron, though, does not mean that you like him. It doesn't mean that. It doesn't mean that you like him. It doesn't mean that you approve of his methods or his words. It doesn't mean any of that to say that he's not guilty of this crime. It doesn't mean that you approve of his tone or his crudeness or how hyperbolic he is, how exaggerating he is in the things that he says. So it doesn't mean any of those things. It simply means that there are various reasonable doubts, and also that the First Amendment applies. And so my hope would be that you recognize the law in regard to reasonable doubts, that you respect his First Amendment rights. I ask of you that. And there are questions, 3 questions that they really cannot answer. And the prosecution, I think, ought to address it. You know, the first question has to do with time. If he's really carrying out this threat, common sense requires us to recognize that 8 years of time times 360 days per have gone by without him ever taking any physical affirmative step toward hurting or harming anybody, including Judge Johnson. And the second question that I don't think they can answer is, where's the evidence in regard to posting the video? It just doesn't exist. Now, they may want to infer it or imply it, but actual evidence is required. In other words, you're not obligated to fill in blanks. And the third question is just about the First Amendment. It's crude hyperbole. How is it anything other? It's crude, it's hyperbole, it's exaggerated, and that video is all about exaggeration, and most importantly, it's fantasy, not real. So I hope they can answer those 3 questions. Maybe they will, maybe they'll address them, maybe they'll ignore them. If they ignore them, then that's a sign to you. And so, members of the jury, I hope that you deliver a verdict for him. This is his only shot at justice. It's you guys. It's all of you. Thank you, and I do thank you for your time and attention. Appreciate it.
Ladies and gentlemen, defense.
Hold on 1 second. Any of you need a short recess before we continue? We've been in session about an hour. Just let me know if you do. Anyone, Charles? Okay, you may proceed.
Ladies and gentlemen, defense said if I don't address those 3 questions, then that's a sign. Well, here's your sign. We'll address them one at a time. When did it become a threat? Well, what is a threat? A threat is not an action, okay? A threat is a word, all right? If he had actually followed through with the threat, today we would be here for murder, all right? But he was charged with a threat, not with murder. A threat does not have the action, and that's the law that you will be given. Would a reasonable, cautious, or prudent person consider it a true threat? Would someone seeing themselves shot to pieces after 7 years of being accosted on the phone? And remember, it got worse. He kept saying this is an 8-year deal. It's not an 8-year deal. That just happened, the video. Before it was phone calls. And what you heard was it got worse, and it got worse, and it got worse. Now, Judge Johnson is seeing herself being portrayed in this video, and she's being killed. 1, she's being called, as I'll put it, a piece of crap. All right? There was more colorful language that the defendant used. Being called a piece of crap, and then having a video of you being murdered, saying target 1, and saying right here that I want to put a bullet in your head, that is an escalation. All right? Now, the defense is trying to say, oh, we brought these charges because that's what the judge demanded. It's the judge that brings charges. No, we bring charges. He said that the judge wanted stalking. He's not charged for stalking, because obviously we make the charging decision. We do that, not the judge. We respect judges, but we decide what to charge. Why did I charge this charge? Because he's guilty of this crime, as you've just seen. All right. Number 2, he said, we can't show that he displayed it. Let me read you, but you'll have this video. You'll get to watch the video of the body cam. And this is what he said. Yeah, I've watched it, and I got a response from my sons and friends, and they watched it too, and they couldn't talk, and they couldn't speak. They couldn't speak after they saw that one. Well, obviously, he just showed it to them. And then once again, when I showed you the short little clip of, he said, the reason why we put it on Brenda's, she gets more views. Now, why does he keep harping on the fact that he didn't upload it? We didn't prove that he uploaded it because we don't have to. And that's why he keeps harping on that. Or he wanted it. He helped it to me. In some way, some fashion, he created it, and it says he showed it to those kids, or son. He wanted it on her TikTok, so he would get more views. He is a part of it. That's why the law was written that way. You don't have to be the one that clicks the button, which is the way defense was trying to portray it for a very specific reason. We don't have to prove that. He said it himself. Reason why is because she gets more views. That's why it's on hers. He did that. Number 3 that he wants me to answer. All right. He's calling it crude hyperbole. You have the freedom of speech. You do not have the freedom to terrorize someone. You do not have the freedom to claim that you're going to execute someone. You do not have the right to ruin somebody else's life. And that's why it stops it with these threats. He made a threat against a very specific person. She did her job. She made a ruling. For 7 years, he's calling on the phone. That's what you heard. Calling on the phone. Saying mean and bad things. They tried to portray it as airing grievances. You know, blasting someone's head over and over and over and saying that I want to kill a judge is not airing a grievance. I'd say threat. And this is not a threat about just going up and beating somebody up. This is making a video of it so that others can see it. Well, what does it matter if others can see it? Well, unless you're wanting to inspire other people. And the most mind-blowing thing I just heard was he's such a good guy, he moved away to get away from her. She ain't done anything to meet him. She doesn't want to meet him. He keeps calling her. How does she know where he's at when he's making this video? Where's he waiting at? She doesn't know. They want to act like he moved away to get away from her. If he wanted to get away from her, he would have quit calling her. He wouldn't make videos about her. He wouldn't do all of these things. He's the obsessed one, not her. She's the one who's in fear because of these videos that are being made and shared on TikTok. Yes, you can air grievances No, you cannot threaten to shoot somebody. Yes, you can disagree with the judge. No, you cannot make a video blasting their head and saying, this is what I want to do. Once again, they harped over and over and over. Well, he didn't do it. Well, we didn't charge you with murder. We charged him with threatening. Would a reasonable, cautious, and prudent person consider it threatening when they hear their name and see it on TikTok of being murdered? Yeah. All I'm asking you is to use your common sense. Did he make a threat? Yeah. Was it posted or transmitted? Yeah, it was posted. You saw it on TikTok. 3. And when I say posted, he says he shared it with his sons. He says he and their friends, and he also talks about that he wanted it on hers because she gets more views. Did he do it in a manner that it may be viewed by other persons? Judge Johnson saw it herself. And like I said, would a prudent person find this to be a threat? Would a cautious person find this to be a threat? Absolutely. I do believe the state has proven beyond a reasonable doubt that the defendant is guilty as charged, and that's what I would ask you mark on the verdict form, is that the defendant is guilty. Defense said it's not the language he would use. I wouldn't use it either because it's a crime. Because what he did was a threat. And you don't have the right to ruin someone else's life. Thank you.
All right, members of the jury, in just a few moments, you'll be taken into the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It's also the foreperson's job to sign and date the verdict form, fold it in half, knock on the door, and bring it back into the courtroom when you have reached a verdict. During deliberations, as I told you before, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the jury returns. You are not to communicate with any person outside the jury about the case until you've reached a verdict. He must not talk about the case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given throughout the case, please give me a note, and if you would, please put it in writing and knock on the door and give it to me. Many of you have cell phones, laptops, tablets, or other electronic devices here in the courtroom. The rules do not allow you to bring those devices into the jury room. So if you have them with you now, you can go ahead and pull them out and lay them on the chair next to you or on the rail in front of you. If you have them in the jury room, before you begin your deliberations, if you'll just go into the jury room and retrieve those and hand them to Boots or Carol, one of the bailiffs here will watch them for you and keep a good eye on them until you have completed your deliberations. If you need to communicate with me in any way other than to let me know that you've reached a verdict, it's necessary that you do so in writing. So you'll have your notepads back there, have the foreperson sign the note when you do submit it, and just knock on the door and hand it to one of the bailiffs. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it'll take some time to get back to you. You may continue your deliberations while you wait for my answer. I'll answer any questions if I can, in writing or orally here back in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent to you in the jury room along with the instructions on the law and the verdict form when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we live by the Constitution and the law, and no juror has the right to violate the rules that all of us share. Are there any additions, corrections, or objections to the instructions given on the law by the state, by the defense? All right. As I told you again, when you reach the verdict, knock on the door, and the foreperson will bring the jury or the verdict form back into the courtroom. If you have any questions that you have other than that you have reached a verdict, please knock on the door, put that question in writing, and have the foreperson sign it, please. Now, with regard to the instructions on the law, some of them have numbers on them, some don't have numbers on them. The ones that do have numbers are not in any sort of sequence, so you'll get them in exactly the same order as I just read them for you. So don't be concerned about the numbers or lack of numbers or the sequence of numbers on the instructions itself. And at this point in time, fortunately, nothing unfortunate has happened to our primary 6 jurors. So Ms. Dixon, you've been our alternate juror. So at this point in time, in a minute, I'm going to excuse you with the thanks of the court. You're welcome to stay if you want to wait upon the decision of the jury. You're also free to leave if you wish. If you choose to leave, make sure you leave your jury badge here, your notepad. We'll collect that, and like I said, we'll destroy it, or I will, after the jury has completed its deliberations. If you choose to stay, if you don't mind having a seat in the jury or in the audience, and if you choose to leave, that's fine, and you're curious about the verdict, just call my office tomorrow. I'll be glad to let you know what the verdict is, okay? At this point in time, you're free to go with the thanks of the court. Pardon? You say Dixon? Yeah. Miss Dixon, you're free to go with the thanks of the court. Do you have anything in the jury room that needs to go back? Okay. If you'll retrieve that for us, please. Staff, thank you again. All right, if I can get counsel to review the exhibits that were admitted, here's the set of instructions, the verdict form. And if you'll review those, if you agree. All right, members of the jury, the admonishment I've given you throughout the case not to discuss it or form any opinions about it is expressly lifted. You're directed to go into the jury room now and consider your verdict. Make sure you first deliver your electronic devices if they're in the jury room, please. Y'all agreed on the exhibits?
Yeah, should I put that with?
Just put it with the exhibits. The verdict form and the instructions are there, correct?
Yes, sir. Our form instructions, exhibits, laptop.
And we'll be in recess. You've agreed upon the laptop, going to blank laptop, going back to the jury room.
Yeah, I think that's fine.
And there's nothing else on it, correct?
No, sir. That's video players. It's not permanent airplane mode. You cannot access the internet or anything on it.
Okay. And we'll be in recess, and if you all want to depart with him, just don't go too far and leave a cell phone number with Misty so we can call you, and then you can be back here in a minute or two if we need you.
She has our cell.
All right. We'll be in recess then until we hear back from the jury.
It is, trust me.
He said, yeah. That's good.
We'll see, sure see.
Outside, it's cultural, so.
I can't believe how many times we use these things. Did you listen to him? I did. Tell you what, you can hear a gnat fart. These things pick up everything. I mean, if you wanted to eavesdrop on someone, you put them on, I bet you could hear someone outside all talking.
said is part of the colloquy that was at the state. A brief factual basis. They right up from the courthouse.
They texted me that.
They were.
Here it is.
We'll come back to order and understand that Yuri has a question. I'll read it into the record and then y'all can review it if you wish. Judge, number one, can we find out when he moved the 600 miles that has been brought up several times? Number two, should we have the wife as a co-conspirator due to account use? Susan Warburton. Well, so number one, they've got to rely on their own conclusions by the evidence. We can't reopen the case. That wasn't brought up when the move took place. Everybody agree?
Yes.
Yes.
So I'll tell you that as to number one. And then number two, should we have the wife as a co-conspirator? How do you want me to answer that?
I'm sorry, I just was hearing.
They have paper shortage too, that little piece of paper they use. I guess I'm gonna start telling them use an old sheet of paper.
We find out when, times, and two, should we know, one, rely on the facts and the evidence, two, should we have the wife as a co-conspirator due to account use?
I think for number two, maybe something like that is not a choice or a topic to be resolved in this trial or in this matter, something like that.
I think
The
that
only
goes to
individual on
procurement.
trial here today is Christopher Campbell. But I've never had such a thing. Should we have them?
I like number two. Because basically we're saying you gotta have her in.
All right. So as to number one, you must rely upon your own recollection of the testimony and the evidence presented. Agreed?
Yes.
And then as to number two. I could say that your duty is to consider the charge brought against this defendant only. Or can you tell them that
I think they can infer, since that it was at least before March of last year. You know, because the deputy went there in, or March of this year.
talking about when you moved there?
When he moved, can we find out when we moved? No, but you can, that he at least, you can see that it was at at least, the evidence showed that in September, there was a post, okay, from someone. The evidence at least showed that in September 2023, that there was a post. Remember when they were talking, when they got a hold of Perez, because Perez got a hold of went and spoke to,
He sent emails to y'all.
not mistaken, it took quite some time from February. February is when Perez actually contacted Young, and then it took several weeks before that, and then additionally, I believe in September when it was posted, you know, we know it was posted in September, and that for Louisiana to be involved, they would have had to be in Louisiana in September.
That is a good argument, but I'm not gonna get into it.
Yeah.
I like what we wrote.
I just trying to put in.
Yeah, sure.
I mean, my dad's never argued with fence posts, so I'm just trying to fulfill his
Well, what you said.
his statements.
You can imply or infer from the evidence.
You can rely on, you must rely on your recollection,
Rely on your
testimony that it's presented. And then as to number two, that's not for their consideration. I can say that.
I'm fine with that, you know, that's not for your consideration here today.
Well, I think we can elucidate a bit more and just say it's not a choice or a topic for this trial, or this case, or this matter, however you might want to say.
That is not an issue to be addressed and discussed here today.
I'm more in line that your duty is to consider the charge against this defendant today. The evidence in the charge or charge against Mr. Gabriel. I think that's correct. You agree?
Not really, I think we need to elucidate a little more because it addresses what they're bringing up when you say it's not topic of choice in this matter or for this case. Not that I disagree with it.
Okay, let's see if I can add to it. Your duty is to consider the charge. His wife is not on trial today?
Yeah.
That's fine.
Okay.
Yes, sir.
Yeah, more simply stated. Maybe that's why you're the judge.
For 49 more days, is that 49 more days?
I love how you know how many days.
I've got a counter downstairs. I can tell you the hours and minutes if I get there. All right, number one, you must rely upon your recollection of the testimony and evidence presented. Number two, your duty is to consider the charge brought against Christopher Campbell. His wife is not on trial today. Agree?
Yes, sir.
And we'll be in recess again.
got a verdict.
All right, clerk, come back to order. Understand the jury's reached a verdict. Okay. Carol, all right, you bring in the jury, please. May be seated. Members of the jury, I understand you reached a verdict, is that correct?
Pardon?
I understand you reached a verdict?
Yes.
Is that correct? If you'll fold that over and hand it to Carol for me, please. All right, and clerk, if you would please publish the verdict.
In the Circuit Court of the Third Judicial Circuit in and for Dixie County, Florida, case number 2476 CF, State of Florida versus Christopher Paul Cameron, defendant. Verdict of the jury. We, the jury, find as follows as to the defendant in this case. The defendant is guilty of written or electronic threat to kill as charged in the information. So say we all, dated at Swanee County, Florida, this 18th day of November 2024, with Susan Richardson as the foreperson.
Thank you. Either of you wish the jury polled?
No, Your Honor.
Yes, Your Honor. All right. Members of the jury, a request has been made that the jury be polled. The purpose of conducting a poll is to verify that the verdict is, in fact, unanimous, a verdict of each of you as well as the jury as a whole. Madam Clerk will be asking you individually a question. If you would listen carefully to it and answer it out loud, please. And I remind you that you're under oath. Go ahead, Misty.
Mr. Edwards, do you agree with the verdict that was just read?
I do.
Mr. McCluskey, do you agree with the verdict that was just read?
Yes, I do.
Ms. Munoz, do you agree with the verdict that was just read? Ms. Richardson, do you agree with the verdict that was just read?
I do.
Mr. Green, do you agree with the verdict that was just read? Ms. Robinson, do you agree with the verdict that was just read?
Yes, I do.
All right, thank you. Either of you aware of any other proceeding that requires the presence of the jury?
No, Your Honor.
Nothing.
All right, and is the defendant entitled to a pre-sentence investigation? State agree?
He has a previous felony where he's been on probation.
Was he convicted?
I think he had a withhold.
Withhold?
I'm going to order a PSI.
In abundance of caution, yes, sir.
Sentencing, is he currently in custody?
Yes.
And is there a bond set in his case?
There's no bond.
All right, he's remanded to the custody of the sheriff without bond pending sentencing in this case. And let's look for a date here real quick, please. We should have sentencing in Dixie County. There's no reason we can't conduct it there, correct?
Correct, Your Honor, in my opinion.
Either of you have a date in mind?
PSI department typically want 3 to 4 weeks, Judge. I'm pulling my calendar up.
They have to do 21 days.
We have Dixie felony pretrial motion date is Wednesday, the 18th.
That's pre-trial day.
I know. It's a, well, Mike says pretrial motion. No, pretrial.
I've got court in Hamilton and here that day.
Yes, sir.
Are there any other court dates in Dixie's schedule?
They have a trial term the week of the Monday, the 9th through the 13th.
Actually, through the 12th, 13th would be Dependency Day.
12th and 13th, you said?
9th through 12th, we have trials, Your Honor.
9th through the 12th.
And the 13th, the courtroom will be full on Dependency Day in Dixie.
Thursday.
I've got the 10th available.
Thursday, 19th is wide open.
Thursday, the 19th is, they have court there. They have misdemeanor non-jury trials.
What date is that?
The 19th. And 10 a.m. delinquency.
I've got a family law case here on that. The best day looked like the 10th for me. Are you available the 10th? December? That's about 3 weeks. That should give them time to do a pre-sentence investigation.
We will have a murder trial going on in Dixie December 10th.
Starting the 10th?
Starting the 9th, going 9, 10, 11.
Use other courtroom.
Yeah, I mean, we have a courtroom B.
Okay. Are y'all available that day? Subject to change, of course.
I think both of us are probably going to be. I think both of us are probably going to be there on that murder trial.
Yes. Are you available the 10th then?
I am, but I'm being told as to conflict and unavailability of the Judge Johnson to be able to testify or speak if she'd like to be heard.
And not available that day?
That week, I'll be doing a bar trial for them in the courthouse, so I'll ask them that on Monday through Thursday.
Well,
Is it the trial week?
I've got the 17th.
Said it's in our email continuing it today.
So the 10th, okay? 10th?
That's during our trial.
17th of December. In the morning.
Do we want to let them, please?
Can make the 10th work? Stay?
We can make the 10th work.
No, I'm sorry. I'm fine. Said the 10th, 17th.
We can make it work.
The week of the 17th is okay with the judge.
17th is good. All right. After all that, I'm going to order a pre-sentence investigation be ordered returnable the 13th of December with copies to counsel on that date as well. Sentencing will take place December the 17th. You want to start it a little bit later than 9? We usually do 9, but if you're going to be traveling, is 11 better? 10, 10:30?
Judge, you can go ahead and start at 9,
I'll just.
Okay. And sentencing will be December the 9th, then, 17th at 9 o'clock. I'm just about to tell you. You're welcome to join us for sentencing. You're not required to be there, of course. So, and if you're curious and you don't want to attend, that's fine. You can contact my office the following day, and I'll be glad to let you know what sentence I impose. A pre-sentence investigation is a report that's done in an investigation into the defendant concerning any background history, circumstances surrounding the case itself that wasn't presented here today. Any history, criminal history will be included in that, and then I'll get that and as well as the lawyers before sentence is imposed. So that's what I'm ordering as well. So the Department of Corrections prepares that for us. I say all that to say this: you're welcome to come. You're not obligated to come. Certainly, if you want to bypass that. Before you go, I want to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by order of this court. For many centuries, our society has relied upon juries for consideration of difficult cases. We've recognized for hundreds of years that the jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak to anyone about your deliberations, you're also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those that are simply curious, those that might seek to find fault with you from the media or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I'm going to discharge you in a few minutes. Before you go, if you have any personal items in the jury room, make sure you retrieve those before you depart. Your cell phone should be right there on the rail. Don't leave those here. Make sure you retrieve those as well. I assume the notepads and evidence are in the jury room. We'll collect those, and like I said, I'll destroy the notes that y'all took and your jury badge. Make sure you can remove those and just hand them to Hank here on the way out as you depart. I want to thank you very much again for your service here. I hope it's a rewarding experience. And at this point in time, you're free to go. Happy Thanksgiving.
Happy Thanksgiving.
And we'll be in session.
Yes, sir.
We'll be in session until the jury departs the courthouse. If I can get the state, please, to notify Department of Corrections of the court's investigation order and dates.
Hey, Jared, that's it's a Dixie. It's a Dixie, so it's going to visit Russell.
Thank you, Joe.
Holler.
How you let us try the case, I appreciate that.
Needs to have it in, what do you say, by the 13th?
They have a rule 21 days.
Returnable.
You'll still be
to the clerk.
A few more days.
Sentencing 17. Thank you, brother. That man there, probably having never
Do we know where John, your sister, was?